made, please.
তুমি ইফালে হ'ব নে মই আমি এপেলেণ্ট লৰ্ড এপেল কৰিছিলো
মই এইটো খুলি দিয়া নতুন
জাজমেণ্টটো দেখাব লাগিব নহয় বাংলাদেশৰ জাজমেণ্টটো
With Lordship's permission, may I make one prayer? By the time learned senior counsel argues, Your Lordship, I want to do one or two cases, Your Lordship. Speaking
It's up to you.
My colleague will be there.
It's up
He
to you.
take the Lordship.
But Mr. Saikia would perhaps made the legal submission. We have already heard from Mr. Gogoi. It is your turn. Then perhaps we can go back to Mr. Saikia. But if you want to address now, you can address.
Yes, Lord.
We'll accommodate for Mr. Botaku for some time. You come back.
Lordship.
How long will you take it?
Yes.
In fact, he has placed everything.
He has placed everything, but what I would like to try to satisfy this honorable court. One thing what was falling from the Lordship's mouth that even if it is not UAPA, then IPC may be attracted.
Yes.
So I will try to impress this honorable court on the provisions of the UAP, Unlawful Prevention Act 1967, specifically provision 16, read with provisions of section 15. So three components I would like to emphasize from the provisions of section 15 and section 16.
15 of the UAPA Act.
UAPA Act. May I read, Lordship, section 15. Terrorist Act. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people of India or in any foreign country. Pausing here for a moment, what I will be emphasizing from my evidence that Akhil Gogoi, accused number A1. A1 was involved in trying to instigate the people to, with an intent to threaten or likely to threaten the unity, integrity, security, economic security, and sovereignty of India. He has actively done it, although the act provides that with an intention to strike terror or likely to strike terror in the people or section of the people in India or in any foreign country. So in India. So this is one part of my argument. It will be, I'll base my evidences on this principle. And number B, then 15(1)(a), Roman 3. Roman 3 says, by disruption of any supply or services essential to the life and community in India or in any foreign country. Roman 2 also, Lordship will take note of. Loss or damage or destruction to the property. And also one, may I just read it? But here it is very, here I will emphasize any other means. So by using bomb, dynamite, etc., I am skipping everything. Lastly, second last line, Lordship will say, by any other means or of whatever nature to cause or likely to cause. So any other means, I will try to satisfy this honorable.
Which provision, please? You have read 15(1)(a)(2).
I read 2, 3, and I am now coming to A, directly A, Roman 1. No, Roman 1 assign like that. A, only A.
Only or by any means.
A is 15(1)(a). And A has got 1, 2, 3, 3A, 4.
Yes, but
You are
within
the
A, within A, by any means and under any means, I will refer to Roman 2 and Roman
by
3.
any other means, okay. Any other substance, any other? By any other?
So there are specific reference of bomb, dynamite, etc. I am skipping all these things. Here, or by any other means, I am referring to. And now, thereafter, death or injury of any person, by any other means, in our case, injury to any other person, the police officer was grievously injured. So one, injuries to any other person. loss or damage of or destruction of property of the police department as well as the railways, disruption of any supply or service essential to the life of the community, rail blockade, rail loco, etc. Then Lordship will kindly come to B. Overalls by means of criminal force or show of criminal force or attempt to do so or causes death of any public functionary or attempts to cause death of any public functionary. Injury to control.
This is police person injury.
Injury to control.
B.
B.
Attempts to cause death. Any public servant.
Injury control.
Attempt to defeat.
So there was an attempt to cause death, but it did not end up with death, but it was grievous injury. So I'll refer to this also.
B.
So
B.
yes, B.
B.
B. So now two lines of from evidences of several PWs, prosecution witness. If Lordship is pleased to take witness number 2, I think is a protected witness.
Which volume? First volume.
Volume 1, Lordship.
Volume 1,
Paper book 1.
PW 1.
Page.
Yes, Lordship. Just 1 second. PW 2, page 9. PW 1 also is there. PW 1, PW 2, both. PW 1 is the protected witness. Here, 5th line. After reaching
Page number 8.
page 8, there was a large gathering and atmosphere of the meeting was very noisy. After reaching Okhil Gogoi, the mood of crowd got more charged. However, Okhil Gogoi addressed the meeting. During his speech, Okhil Gogoi provoked the people and asked them to oppose the government by any means, whether they had to do anything, force it. Due to his provocation, some people from the crowd started pelting stones on security officials. One of those stones hit on the mouth of Tulumoni Dwara, OC of Chabua PS. He got grievously injured, and two of his teeth were broken and was bleeding profusely. Even then, the crowd did not stop and overturned and damaged the Bolero vehicles on the road, probably on government duty. Even after turning off crowd violence, Okhil Gogoi did not denounce the same or did anything to stop them. So this is one part which directly attracts the provisions of section 15B. Next page, Tulumoni Dwara's statement, PW2. So we do not have the identity. I'm not disclosing the identity of protected witness, Lordship. Now coming to Tulumoni Dwara, who was the officer,
On duty officer.
so he is the officer in charge of Sabua PS since July 2019, and I am holding the post till date. In second paragraph, last line. Now, may I read, Lordship? Third paragraph, fourth paragraph. On being asked, further state that on 9/12/2019, when I, along with my PS staff and additional SP headquarters, was performing law and order duty at Sabua town, as there was a gathering of about 6,000 people headed and addressed by Mr. AG, leader of KMSS. They blocked the railway track as part of economic blockade. So provision of 16 comes again. 15, economic blockade. 15, C, disruption of any supplies or services essential to the life of community. So they blocked the railway track as part of economic blockade. I also saw that they had damaged a gypsy vehicle under Indo-Tibetan Border Police, ITBP, which was passing on National Highway going to Arunachal Pradesh. During the meeting, I got information from Devarikhi Chetia that some protesters were planning to burn down the house of Bengali-dominated Amravati colony. This I'll come PW 4142. I immediately informed Subhash Chandra Kochari, Circle Inspector, regarding the situation and further requested him to deploy police party of reserve in the area. that Bengali dominated area. Next, we went further to stop them and tried to remove the blockade, but it was in vain as they were provoked by Akhil Gogoi. The leader of the crowd, Akhil Gogoi and his associates criminally conspired against police and government officials and threw stones at us. So specific allegation that Akhil Gogoi and his associates conspired and threw stones at the police. One of those stones hit my mouth, injuring my two teeth, where one teeth completely broken and got sustained grievous injuries in my upper jaw, upper lip. Another stone hit my head. It could have been fatal also, Lordship. Another stone hit my head, but I was wearing a helmet. Immediately, I went to Model Hospital. Then doctors referred to Aditya Nursing Home for better treatment. And doctor gave me stitches and other treatment. One of my teeth had to be completely removed, and another one is about to be removed. It was an attempt of murder on part of their conspiracy against police who were deployed there to maintain law and order situation. So when we go to a dentist, Lordship, to remove a teeth, it is such a painful exercise. You have to take anesthesia, and it's a very tedious effort. But here on a stone throw, it removed one of his teeth, and another hit his head. Luckily, he was wearing a helmet. So attempt is also comes under UAPA. Next, and the person, PW's 19 will testify all these things, the doctor, these injuries, PW 19. At the same time, associates of Akhil Gogoi also damaged a white Bolero vehicle on duty under CRPF. They had turned a vehicle over on its side. That is, one is ITBP's Gypsy. Now it is another different vehicle. Akhil Gogoi and his associates, by way of their action, obstructed the police and government officials from performing their duty. So this I am not taking UAPA, IPC will take care of this. The gathering of people was still being addressed by Akhil Gogoi, leader of KMS, and I got injured and was being shifted away from the site. So I am now coming to next PW3. Hogan Loskar, another police officer, he's a SI. Here also basically narration of the same story. I will not trouble your lordship. Lordship will kindly come to PW 5. Sanjeev Chetia. I am serving as a UBC, that is armed branch constable. On 9/12/2019, Akhil Gogoi, the leader of Krikhak Mukti Khongram, organized a rail blockade at Chabua railway station to protest against the CAB, and approximately 6,000 to 7,000 people gathered there. We, along with OC, staff, and Honorable SPH headquarters, Dibrugarh, were on LO duty at that place. When the people present at the meeting got agitated and prevented the movement of vehicles along on National Highway 37, we, along with the OC and the district administration, tried to clear the road. At 7 p.m., some agitated people led by Akhil Gogoi. So it is not that some stray persons, it is led by Akhil Gogoi. So that word led is very important here. Led by Akhil Gogoi, started pelting stones at the police party. Though we were not injured, the OC was struck by stone on his face, as a result of which two of his teeth got broken and he sustained a cut in his upper lip. Coming to next page, Lordship, PW 6. Another police. Basically, same. So all his statement, also the second paragraph. Here, about 5 lines. The people present at the meeting became agitated and blocked National Highway 37 and thus prevented the movement of vehicles along the road. When we, along with the district administration and the OC, tried to clear the road at about 7 p.m., some agitated people, again using the word led by Akhil Gogoi, started throwing stone at us. Though we are not injured, OC got injured. So UAPA 1B. Identical at PW 7 also. PW8 also identical statements, Lordship. Everywhere it has been there, people led by Akhil Gogoi. Now PW9, statement of Mohammad Rafiq Shah. So he is not from police. All others were police. So we have witnesses from various quarters of the society. My name and address is given above are true. I am the VDP president of Sabwa town. On 9/12/2019, a rally was held at Sabwa railway station under the leadership of Akhil Gogoi to protest against CAB, with around 7,000 to 8,000 people gathering to carry out a rail blockade program. In that rally, I, along with VDP members Birendra Sharma and Biju Chaudhary, were also doing our duty. In that place, OC of Sabwa police station was also doing his duty along with his staff. At around 7 p.m., I saw some agitated people pelting stones on the vehicles plying on NH37. When I informed the OC about that, he, accompanied by his staff, proceeded to that place and tried to resist the protesters. Thereupon, protesters were also attacked by police with stone. I saw the OC had sustained injuries on his mouth as a result of being pelted with stones. So here, the important word is third line, leadership of Akhil Gogoi. And this is given by Mohammad Rafiq, who is the president of Village Defense Party. Then next, PW 10, here he is Birendra Sharma. I think he is also the VDP person because his name is mentioned by the previous witness. Yes, Birendra Sharma, another member of the VDP. He also said the same thing, PW 10. PW 11, Biju Chaudhary, part of VDP. He also said led by Akhil Gogoi. Now coming to PW 12, Subhas Kochari. He is the circle inspector of Sabwa police station. May I read 2-3 paragraphs from this? Third line. In the afternoon of 9/12/2019, upon receiving information from OC of Sabwa PS, the CAB protesters led by Akhil Gogoi, the Krikok Mukti Sangram Samiti leader, were holding a rally near Sabwa police station close to the railway station to carry out a railway blockade. Then Lordship will come to about 7 lines from below. But around 6 p.m., Akhil Gogoi, the leader of KMSS, created a tense situation at the place of the rally by delivering a long speech against CAB, criticizing the directives of the present BJP government, and thus instigating the people present there to execute rail blockade program as a part of economic blockade. Specific word has been used here, Lordship. We have not put this word in his mouth. As part of economic blockade, and that word we find in UAPA Act, thereby provoking the people present there to build a violent movement. Immediately after that, some people from the rally tried to stop the vehicles plying on the highway by pelting stones, thereby damaging them. And when the police personnel tried to resist them, the agitated public attacked the police also, and as a result, OC sustained grievous injuries. Next page, Lordship. Lokshinath Bosumotari. Here, about 5 lines from top. During the protest, PW 13, Akhil Gogoi, the leader of the KMSS, delivered an instigatory speech calling for violent movement and blocking of railways as part of the economic blockade. As a result, the agitated crowd started vandalizing passing vehicles by pelting stones. They also attacked the police party with stones, causing grievous injuries to the OC of the police station, including breaking of 2 of his teeth. I heard Akhil Gogoi's speech. I state that the violent incident occurred as direct consequence of his instigation. In his speech, Akhil Gogoi urged the people to disrupt the functioning of all government establishments in Assam. It also comes under UAPA. UAPA says, Lordship, that the life of the country has to be stopped. In his speech, Akhil Gogoi urged the people to disrupt the functioning of all government establishments in Assam in order to paralyze the government machinery and to stop plying of vehicles on the national highway. In its aftermath, the enraged crowd vandalized several structures in Sabua, including railway station, post office, UBI bank, circle officer's office, and the residence of local MLA by setting them ablaze. What more is required, Lordship? The local MLA's house is burned, banks are vandalized, post office were vandalized, railway station was burnt. I'll show the photographs also. The photographs are part of the charge sheet. So nothing more requires Lordship to come and try the accused person under UAPA. And there are electronic evidence also, the videos, which was obtained from the journalist of Proceedings Time. I'll place all those. Next is witness of Dipen Gogoi, PW 14. Basically the same thing, economic blockade, instigation, vandalizing. Nobin Gogoi, same, more or less same statement. Vicky Kondopan, PW 15. Now coming to PW 16. Now he is the IO. My name is recorded by Inspector. My name and address recorded are I drive vehicles of Sabua police station. In the afternoon of so-and-so, as per the instruction of officer in charge, I dropped him and the accompanying police party at Sabua Sariali, a junction of 4 roads. After parking of the vehicles on the roadside, I remained seated inside. At that time, a large crowd gathered near the railway station where a rally was going on regarding a rail roko movement, that is railway blockade. As soon as KMS leader Akhil Gogoi finished his speech, some people began vandalizing passing vehicles by pelting stones. When the police personnel tried to stop them, the agitated crowd attacked the police party with stones. In the attack, the OC of Sabua sustained grievous injuries. Next is Dhruva Bora, PW 17, page 30, second line, third line from below. A protest program railway block was undertaken by people of Sabua under the leadership of Akhil Gogoi. In his speech, instigated people of Sabua, and as a result, the crowd started pelting stones on us, and one stone hit OC Chabua. That what instigated. Then PW 18. Here a journalist from Proceedings Time. My name and address above. I am a local correspondent of Proceedings Time. During CAB, which has become CAA now, I was in Chabua on 9th December. Assam Bond was given by Krikhak Mukti Sangram Committee and other organizations. On that day, at evening time, there was huge gathering at Sabua town comprising of 6,000. Akhil Gogoi and some of his companions arrived at the meeting venue at 6 p.m. The meeting was arranged near Sabua railway station. As soon as Akhil Gogoi arrived, he asked people to sit on the railway track to block the rails. After some time, while the provocating lecture of chief guest Akhil Gogoi was going on, people got more furious and started pelting of stones upon the security personnel. Seeing the hue and cry, I rushed towards the main road on NH 737, where the security personnel were mainly present. On the way, I saw OC of Sabua PS, Mr. Tulumoni Dwara, sustained injury on his face and was bleeding. He told me that he was hit because of pelting of stones by the supporters of Akhil Gogoi. I took the video footages of the injured OC as well as the meeting environment. Akhil's lecture was still going on. There was no peaceful environment, although the environment was already noisy. One bolero was also damaged there because of the instigational speech delivered by Akhil Gogoi. A journalist is saying, Lordship. We cannot put words in the mouth of a journalist. Instigational speech delivered by Akhil Gogoi. Bolero belongs to security personnel of CRPA. Now, one question. Who took the lead of gathering so many crowd at the venue? The journalist said, I think it was the organizer, including KMSS, who gathered so many public there. It should be their responsibility to make the environment peaceful. At least Akhil could have managed the situation as he was the only guest lecturer there. After the vandalism, Akhil and others remained for an hour there. Next question. What was the gist of the speech of Akhil Gogoi at a meeting? It was against government. He warned people against probable infiltration of Bangladeshi into Assam and asked all to intensify the protest. That intensify the protest is the critical part of this statement. He instigated to continue with the movement, and the movement turned very violent. It could have been a peaceful movement also, but it did not. So he asked all to intensify the movement. So as a part of this, complying to the request made by the chief guest, chief speaker, the people started pelting stones on the police party, turning the vehicle upside, attacking the vehicles flying on the national highway. And little later, burned the Sabwa railway station, burned the UBI bank, went to the house of the local MLA, burned his house also. So this is a part of the instigation. This is the part of the intensification of the protest. Did Akhil requested the crowd not to vandalize? I did not see. So that shows it is a tacit approval of all the acts done by his supporters. If he had stopped, had Mahatma Gandhi been there, he would have stopped because his policy was non-violence. But here it is just the reverse. The note of the police officer I am not reading because the next part is the note. Last paragraph of that note, it also reveals that it was a planned miscreant as well as Maoist terrorist designed activity in the name of protest against CA in Sabwa.
Which part?
The last paragraph of page 33. Now coming to next, Dr. Sinmoy Ranjan, that is the doctor, Sinmoy Ranjan Joshi. Paragraph second, he is the doctor of Aditya Multi-Speciality Dental Clinic, Dibrugarh. Second, on being asked, I further state that on 9/12/2019, I received one call from Casualty Department at about 8 p.m. in the evening regarding one emergency case of stone pelting injury of one police officer. Accordingly, I attended the patient.
Just a minute, Mr. Secretary.
আজি তো মই এটা কংগ্ৰেছৰ কেছ কৰি থকাৰ নিচিনা হৈছে এটা কংগ্ৰেছ উকিলৰ এইখিনি একো ঠিক নাই মই উকিল বাকী মই গৌৰৱ গগৈৰ কেছ কৰি থৈছো উকিলক জিকাটো বিচাৰিব এতিয়া ক'ব পাৰিবি ক'ব পাৰি আমি উকিল হৈ থকাই ভাল এইবিলাকত যোৱাত So the doctor said, I attended the patient Sri Tulumoni Dwara.
Taking a verification, this page 33.
Yes.
After the question, these are also statements, not a.
No, I am not sure about that. I asked my colleague. It's a statement. It's a part of statement.
What's the statement?
In the morning you said it's a note of the. No, it's a part of the statement.
What is the statement?
In that case, I read the whole, Lordship. Next. Akhil Gogoi is an influential
note. Then first time from where it came, the question might arise. But if it's a statement, he can say all the statement.
Lordship.
It looks like a statement.
Even to me also, there is a doubt in my mind also when I was preparing the case. It's a statement, Lordship. Lordship. So I stand corrected, Lordship. I'm obliged. Now may I read the continuation of the third part of I did not see. Then he went.
You're reading Chinmaranjan?
Yes, yes, yes.
Doctor.
No. Biswajit Phukon.
Page?
33.
Oh, same.
Yes. The last question, did Okhil ask the crowd not to vandalize? Answer is, I did not see. Then he went further. Okhil Gogoi is an influential person and can provoke crowd by his strong voice. It is seen that soon after the arrest and judicial detention of accused Okhil Gogoi, some neutral witnesses acquainted with the facts of the case are willing to come forward and will surely cooperate with the entire investigation process. Therefore, his judicial custody is essential for getting more evidence the sake of fair investigation. As per order of Honorable High Court, Gauhati High Court, all kind of bond calls given by some various organizations is illegal and all the liabilities be vested upon the organization. Being the advisor of KMSS Assam, the accused Okhil Gogoi is fully responsible in all the miscreant activities that took place in Sabua during the bond call given by them. Also, it reveals that it was a planned miscreant as well as Maoist terrorist designed activity in the name of protest against CAA in Sabua. I don't know why the journalist said all these things. High Court or judgment or like your call. No, get a opinion delay case of certificate case of backbending exercise to court and Supreme Court of judgment of by one of the backbender analysis that could be the facts person.
Yes.
Next page is a doctor's statement, Lordship.
34.
34. PW 19. Third line from in paragraph 2. Accordingly, I attended the patient, Tulumoni Dwara. I found there was 4x4 cm laceration over his right upper lip region. He had a mobile fracture segment in relation to 4x4 Roman 2 tooth crown was fractured also. We had removed the fractured part. Later on, we did investigations such as CT scan of the face. The final diagnosis was dentoventricular fracture and soft tissue. Laceration of the right upper lip. There was also a cut inside oral, so and so, 4x4. Treatment done, these are the treatment. So whatever is stated, it has been substantiated by the report of the doctor. And regarding the previous statement there, I'll come to that later on. The video footage was also given by the journalist. I'll place that once we place
PW 18.
PW 18. Yeah, that lordship will find video reporter. Lordship will find that data at page 287. The journalist submitted all these data, which was page 279. Sabua public road blockade. In this clip, serial number 6 in page 279. Yes, page 278. Lordship will kindly take note of that also. Scrutiny report data provided by Proceeding Time of Gauhati in 1 CD at the heading, page 278. And Lordship will kindly come to page 279, serial number 6. That's I think look like we take it.
Serial 6.
278 and serial number 6, 279. 3 yes. Yes. Serial number 3, Lordship, will kindly see
Yes.
that video. In this clip, Akhil Gogoi A1 is welcoming the protesters and saying that the fire would be spread. Serial number 2, in this clip, protesters were damaging the vehicle, Mahindra vehicle. Video number 1, a police officer has a grievous injury. These are all electronic evidences and which was finally confirmed by the forensic laboratories also. Then serial number 4, in this clip, mob has used inflammable substances to burn down tires on the road, of vehicles on the road. The 5 is not very, the mob is gathered via motorcycle rally. 6, in this clip, protesters were blocking road by big stones and burnt tires on the road, thereby disrupting supplies essential for life of the community in India using inflammable substances. So section 15. 6, 7, the mob is gathered in pursuance of the Conspiracy of Terrorists Act of damaging properties, attempting to kill government functionaries on duty. So all these video evidences are also there, electronic evidence. Now coming back again to the witnesses, Lordship. So paragraph PW 20, 21, 22, these are how the electronic evidences were recorded and assessed. The various statements were given by the concerned technical persons. So all the requirements under the IT Act are complied with. So that there is no technical flaw of analyzing, receiving, analyzing the electronic evidences. Now, PW 23. So he is the driver of the vehicle Mahindra Bolero. His vehicle was used by CRPF. May I read it, Lord? Page 41. I am above mentioned. On being asked, I am to state that I have been driving vehicle AS6 V2392 Mahindra Bolero since 2018. The owner of the vehicle is Wahida Chaudhary of Dibrugarh. Initially, this vehicle was given to CRPF Duliajan on hire. From August 2019, I came to perform duty under 171 Battalion Koi of CRPF Sabwa. I have been driving this vehicle with CRPF party and mostly reported in local PS Sabwa for various duties along with CRPF and police. On 9/12/2019, I took Koi Commander DSP of CRPF from his camp to Chabua PS. The company commander and CRPF party left from Thana by bus towards protest place at Sabwa, and most of the time of the day I remained in Thana. At about 6:30, 6:45, the company commander CRPF called me and accordingly I went their duty place in highway, which was a little distance from the meeting place towards Tinsukia. I parked my vehicle near the road on railway line sideline. At that time, near my vehicle, there was not much crowd. As soon as I parked the vehicle, I noticed in a distance about 100 meters towards meeting place, one gypsy vehicle was coming in highway, and large number of violent protesters start and ran behind it and attacked it by pelting stones. Looking at the dangerous situation, I tried to drive out my vehicle from the place, but already crowd came from both sides of the road and blocked my vehicle. Violent protesters already started pelting stones in my vehicle, and some of them attacked and tried to pull me out from my vehicle. Somehow I came out from the vehicle and ran towards the marketplace of the town and hid under some bushes and saved myself. From my hiding place, I called the company commander CRPF, and about 10 minutes, he assured me and asked me to come out. So I came out and reached near the vehicle. I saw that both windshield, one looking mirror, and all glasses of the left side were break. It should have been broken by the violent protesters, and they also caused damage in body of the vehicle. At that time, I called OC sir, but from him I came to know that he himself sustained injuries on his face by some violent protester. Due to the darkness, there was a huge crowd and I could not identify any of the protesters clearly. I drove my vehicle up to Thana and parked it there. I also informed the matter to the owners of the vehicle. So this is sufficient. The next is Trilushan Behera, Assistant Commandant, 171 Battalion CRPF, post PW 24. I state that I joined CRPF in the month of 30/8/1994 and presently posted in Panitola BDO office, Dibrugarh from 18/8/2019 as a assistant commandant. On 9/12/2019, I was detailed at Chabua near railway station along with my company for law and order duty in connection with 12 hours Assam Bandh given by the various organizations. That day, a protest against CAB, now called CA, was going on at Sabua. Around 1800 hours, Okhil Gogoi along with his associates came to Sabua near railway station incident place and addressed the crowd. During the addressing of the crowd, he delivered the provocative speech to the crowd and told the people to oppose the bill, now CAA, using any means, whether they had to do anything from it. On his provocation, some people from the crowd started pelting stones and one stone hit the mouth of Tulumani Dwara, OC of Sabua, and he got injured and two of his teeth were broken. Even then, the crowd did not stop and overturned our government allotted vehicle upside down, Bolero so-and-so, driven by one Vicky. The vehicle was damaged due to this act. After much deliberation, the crowd were pacified and next day I lodged a complaint against this at Sabua PS. Then next 25, railway property damage here. Statement of E.K. Medhi. I am the above mentioned. On being asked, I stated I have been posted at GRP, New Gauhati since, but due to CAB, I was posted at GRP Tinsukia on emergency basis by senior authority. They are posted in the railway station. On being asked, I further state that anti-CAB protest programs were conducted by various organizations in entire Tinsukia and Dibrugarh district, like other parts of Assam. Such programs were intensified from November 2019. On 9/12/2019 at 2100 hours, our control room message received from SS Sabua regarding rail Aborod program conducted at Sabua railway station by about 1000 picketers of Citizenship Amendment Bill 2019 Birudhi Monch. So 15907 down Naharlogun Express detained at Sabua from 16:35 hours on 16/12/2019. One complaint submitted by ACM Sri Porimal Mali regarding loss and damaged properties in different railway stations, including Sabua railway station during CAB protest. Also, one complaint submitted by Sotish Borua SS Sabua regarding setting fire and damage other railway properties on 11/12/2019 on the basis of complaint. One case was registered at GRPF Thana Tinsukia under section so-and-so. Due to COVID, I shifted to Dibrugarh as ICGRP. On 1/6/2000, the NI official came to my Thana and upon their requisition, I provide certified copies of FIR, complaint, etc. to them. Lordship will kindly see the photograph how the railway station was damaged. Railway damage properties. Yes, sir. Two volume.
Two volumes. Volume 2. Paper 2.
In paper book 2, photo. Probably it's given. I'll come to that, Lordship, in a minute. The photographs are very clear. Next is PW 26. T. Shanti Kumar. I am working as Inspector in Charge RPF post Tinsukia since 13/4/2017. I joined as SI RPF in the year 19. On being asked, I further state that on 9/12/2019 at about 1600 hours, about 1000 picketers of Nagorikotto Honkudhoni Bidhayak Birudhi Moncha under the leadership of Deborsi Chotia, working president, and C. Dipen Jyoti Phukon president, so and so, resorted to Rail Roko against Citizenship Amendment Act at Sabua. The agitators obstructed the working of duty of railway servants on duty crew number so and so train. SDC Sabua, OC Sabua, IP, NTSK along with staff attended the spot to control the law and order situation. The above officials severely asked the agitators to leave from the agitation site, but the agitators disobeyed the lawful directions given by the civil and railway administration. The agitators have withdrawn their agitation at about 21:05 hours on 9/12/2000 due to the sale rail loco agitation train number so and so were detained. No attempt could be made to arrest the picketers for taking legal action as it might deteriorate law and order situation of the agitation. In this connection, a formal FIR is also lodged by so and so for legal action. Now here, the argument from the other side could come that Okhil Gogoi's name is not figuring. But all the things have instigated from that fiery speech where they wanted to intensify the protest. So these are all offshoot of that instigation. Now coming to in paper book 2, Lordship, page number 392.
Page number
Page 392 of paper book 2.
2. Yes.
How they were squatting on the railway track. Then 393, how the properties were all burned and damaged, vandalized in the railway station. 394, Lordship can maybe please to look at. On the left hand upper side, the platform, the roofs are visible.
394.
394.
Yes.
Left hand side, top corner.
Yes.
Then page
What is that
395.
left hand side top corner?
Top, that roof of the platform.
Yes.
The damage is the house. It may not be connected with here. Suppose those roofs are not built, then it can be any other house. But here you can visualize it, and it is a part of the platform. Then page 395, the railway track, rail oborud, etc. These people were sitting there from 4 p.m. That's 1600 hours. Okhil Gogoi arrived at around 6 p.m. And all this happened thereafter. Once that fiery speech, where he urged the people to intensify the protest. Okhil Gogoi did not say that go and burn the railway station or damage the bank or set ablaze the MLA's house. He did not say that. But the way he encouraged the people and instigated the people, provoked the people to intensify the protesters. People started pelting stone at police persons. People started damaging the vehicles parked there, stopping the vehicles flying on the highway. And next days, they went to the railway station, which is very near, not even 100 meters from that site, started damaging the railway station, burning the railway station. Offices were damaged, trains were blocked, and also thereafter damage the nearby government structures, which includes the bank. Bank is not a government structure, but it is a public property.
Who has said about the bank property?
Lordship.
Which witnesses said regarding the damage to the bank building?
Yes, I have. Bank को टूलिए दिया बैंक के जब भांगी थे. Yes, page 25, PW 13. Last 6 lines. In his speech, have Lordship got it?
Yes.
In his speech, Akhil Gogoi urged the people to disrupt the functioning of all government establishments in Assam in order to paralyze the government machinery and to stop flying of vehicles on national highway. In its aftermath, the enraged crowds vandalized several structures in Sabwa, including railway station, post office, UBI bank, circle officer's office, and the residence of local MLA by setting them ablaze. So we have to connect all these dots, the sequence of events, and that will be possible only through a proper detailed trial. At this stage, when the learned trial court decided on the issue of framing of charge, all these details cannot be gone into. I'll place the law, which Lordship is well aware. I have to repeat only. At the stage of framing of charge, Lordship, up to what extent the court will examine the evidence before it. The whole property list, damaged properties list also Lordship will find.
Commercial department, only commercial department business. If only the commercial.
Page 308, paper book 2. Page 302. This is only a small portion of the damage. I'm just indicating. It is not the quantum or the size of the property damage. That depends. Even there's a loss of 1 lakh rupees also property. That is also attract the same 308. The document 41. Commercial department is one part of the railway station. Assessment of loss of railway properties pertaining to commercial department caused by miscreants on during CAB protest. Panitola, Sabwa, Lordship will see.
Yes.
Thin client, monitor, keyboard, UTS printer, etc. These approximately 10 UTS ticket rolls, so and so. These were damaged there. So again, coming to witness 28, he mentioned about the assessment of loss and damage property list. So he mentioned about that. Now coming to station superintendent statement, PW 29. Statement in respect of Satish Borua, station superintendent of Sabwa, age 54. The second paragraph. On being asked, I further state that on 9/12/2019, I pick up my shift duty at around 18:30. That means 6:30. Before that, Kaushik Haldar ASM was on duty, and during his time, he told me over phone that there was a large number of picketers of anti-CAB movement gathered in Sabwa town and railway station. Also, they were planning to block the movement of Rajdhani Express. Pausing here for a moment. The earlier organization started from 4 p.m. Okhil Gogoi arrived at 6 p.m. These are all telephonic records. So till that time when he took charge at 6:30, nothing was happening. They were planning. So from 4 o'clock, there was a planning going on, but it was not executed. When Okhil Gogoi arrived and he inspired the people and provoked the people, then all these violent activities followed. They were planning to block the movement of Rajdhani Express and up Kamrup Express. After getting that information, I became alarmed, and when I reached station, found a large number of crowd present in the railway platform, railway track and nearby civil areas. The message I received that DN Naharlagun Express was already detained at outside Sabua railway station. Kamrup Express was detained at Dikom station, and Rajdhani Express was controlled at Dibrugarh station for precautionary measures. When I pick up my duty, protest program was continuing at platform and station area, and a large number of protesters present there. For my duty as well as out of here, I remained inside my office, and from there I saw different leaders of various organizations delivered lectures, but I personally could not identify any of them. I also sent control message of addressing to OC, RPF, GRPF, Security Control, Tinsukia, CHE, all concerned around 1900 hours. The program finally finished almost after 8 p.m. and Naharlagun Express arrived at Sabwa at 10:30. From next day onwards, law and order situation became worse and my reliever unable to come for duty. So I continue my duty till 5 a.m. on 11/12/2000. Finally, my reliever, Raman Kumar so came and relieved me after 5 a.m. I went back home. Later, I came to know that the situation became more violent, and on 11/12/2019, miscreants set fire to Sabwa station and damaged considerable loss. And on duty, ASM Raman Kumar shut down the station and left. So station was shut down also. The damage was so severe. Due to law and order situation, I could not come out from my home, and finally on Hmm?
We are on with the incident.
Yes, Mr. Sakya. As regards the incident which occurred on 11th, whether separate FIR was lodged.
What I am trying to say that after Okhil Gogoi is entering into the scenario, the things followed. These are all consequential action. So he did not himself set anything on fire. He instigated the people. He instigated the people. He activated the people, and he said that intensify your protest. And these are all, as a result of his instigation, all these things followed up, one after another. It did not have to happen immediately, but before his arrival, things were very peaceful. Before and after, we have to see. But when he was there, police officials were attacked. When he was there, vehicles were damaged. When he was there, the vehicles were turned upside down. When he was there, the movement of the traffic on the national highway was stalled. This is the additional part I am saying. This is another component. There are various levers, various verticals of the incident. That is why in section 15 and section 16, I have said several
No,
parts are there.
But for incident which occurred on 11th.
Here 11, but other incidents all were on 10th, 9th.
Yes, this which you are referring now.
Because
For that,
I said that follow this path. The action will follow not maybe after 1 hour, maybe after 1 day, maybe after 2 days.
Like, yeah, what we are trying to get a clarification is that for the incident which happened on
Ninth.
the 9th, the FIR was already lodged on 10/12. It was registered 10/12. You did not wait till the next date or till 11 that your consolidated FIR because you did not anticipate. It is very it is desired to lodge the FIR promptly, which you have done. But the escalation continued, it did not stop. 11th, something else happened for which there is another investigation, another case registered. We are only examining.
No, that part is the investigation regarding the damage in the railway station, which they are internally doing, the GRPF. But this is a part of the other investigation, the other investigation undertaken by NIA. If Lordship is pleased to come to 279.
Your submission is that the burning of railway station on 11th
Is a
is a
consequential action.
consequence of
It's a
the
consequential
provocative
action.
speech of Akhil Gogoi and 9th.
Yes,
Is this your submission?
absolutely correct, Lord. That is why page 279, paper book 1. Paper book 1. The video statement, serial number 3, given by the Proceedings and journalist. Video number 3. In this clip,
Yes.
I am not taking away incident of 8 December. I am taking away incident of 11 December. So now, when this journalist recorded Akhil Gogoi's version, video number 3 says, in this clip, Akhil Gogoi A1 is welcoming the protesters and saying that fire would be spread. That means some subsequent action will take place in which there will be fire. So we have to take out the meaning of what fire means here.
No, fire doesn't mean literal fire.
Exactly.
Fire means the agitation will spread. That is how spreading of fire doesn't mean that something has to be set ablaze. It's a different matter. That
I fully agree. It is not, I'm talking about the MLA's house being burnt. I'm not on that. Fire will be spread, that it will become more aggressive. Aggressive. So when that aggression leads to closing of the railway station due to damage and vandalism, destruction of a bank, destruction of a circle office, all these things followed. And who is instrumental for all this action? There may be other leaders also. My friend is right. There may be other leaders also. Big political personalities' names are also there in the telephonic conversation. I'll place all those. But various statements says he is the chief speaker. He is the lone speaker. That statement is also there. And once he gave the state, de-establish the economy, that is sufficient. Under that, a lot of things can happen. And we have to see what are the things that have happened. Everything is related with violence. Everything is related with national security. Everything is related with de-establishing the economy of the state or stalling the activities of the government, stalling the activities of the economic part of the state. What does it signify that when a rail blockade is done? It is ultimately a form of economic blockade. So we cannot ignore this statement given in a video. That will have to be examined and tested during a trial, because this video may be a morphed video also. It may be a correct video. But according to the report which we have received from Chandigarh, the Forensic Science Laboratory, FSL in Chandigarh, CFL, it is said that this is not a morphed video, it is a genuine video. So that the learned trial court judge at this stage of framing of charge cannot ignore. Finally, if it is proved by the defense counsel that this is a morphed video, or the evidence given on electronic basis is not reliable, then he will get the benefit of doubt, or that he may get the acquittal. But before trial, we cannot make up our mind when I have specific video clippings from with a specific certificate from a reputed central government agency with all the requirements under the Information Technology Act, all those certificates, etc. We cannot ignore that. Statement of these people are okay, fine. But what about the electronic, which are more reliable? Now the Jubin Garg's case, all the videos are taken. Those videos are actually making the case strong. So from this lordship, we cannot ignore, because this is more reliable than the statement of my learned friend. May also say that the journalist, he has been influenced. The police officials, they may be influenced. The railway officers, they may be influenced. But what about the evidence given on electronic materials? This scientific evidence cannot be ignored, and they have lot of the level of reliability on electronic and scientific evidence is much more than the oral evidence of a particular person. So when the videos, his statement is saying that the fire would be spread, that is sufficient to give the indication. So now Deborakhi Setia's statement, PW 30. Statement in respect of Deborakhi Chetia, so and so, recorded. I am the above person on being I am a by profession, I am class 1 contractor of Public Works Department, and I am AGS Central Unit Motok Jubo Chhatra Sonnmilan. In the year 2018, probably in the month of October, November, almost all 70 various organizations from different communities, local clubs, ladies organizations, etc. of Sabua come under the one umbrella called Nagorikotto Sangshodhani Bidheyak 2016 Birudhi Moncha. So he is a part of this organization who was opposing CAB as well as CAA. To fight against CAB together, KMS leader Ukhil Gogoi, Sri Opurva Borua, retired Nehu professor, Ajit Kumar Bhuya, and some other prominent leaders of various organizations were present there. On being asked, I further state that unlike other organizations under this umbrella, our organization also took part in various protest programs in different places. But when the CAB movement, the CAB about to pass in Rajya Sabha, the movement became more intensified during the period of October 2019 till its end. Various organizations, including our organization under umbrella of Nahorkotia, Sangshodhani Bidheyak Birudhi Moncha 2016, planning for various protest programs, including Rail Roko protest, march meeting, etc. Accordingly, on 9/12/2019, people from local areas started gathering near Sabwa railway station and market area at around 5:40 to 6 p.m. Different leaders from various organizations like ATSA, All Assam Yuva Chhatra Parishad, DYFI, KMSS, etc. began to deliver their lecture regarding protests against CAB, where KMS leader Ukhil Gogoi and others also delivered aggressive and provocative speech. In that program, larger number of people came voluntarily in that meeting, due to which road traffic was disrupted, and I, along with other organizers, tried to clear the highway. The program of Rail Loco was there. As per my knowledge, no permission from civil authority was taken to organize protest/meeting program in Chabua on 9/12/2019. During that time, ADC Sri Ranjit Kaur and some others informed me about some protesters there were trying to create violence near the meeting place to disturb law and order situation. At about 6:45 p.m., I heard one message that one CRPF vehicle was damaged by some protesters at about half kilometer from the meeting place towards Panitola side. At that time, Sri Tulumoti Dwara, SI OC Sabua PS, along with his staff were near to me in his duty. As soon as he received the news, he along with staff went towards the PO where the CRPF vehicle was damaged. I along with few of my companions followed him. When I reached the place, I saw OC sir was attacked by protesters causing serious injury on his face due to stone pelting. At that time, I saw Bhupen Gogoi, Bhaskarjit Phukon, alias Swaraditya Phukon and Jagjit Guhai were along with other protesters who near the damaged vehicle and while I tried to remove one burning tire from the road, Swargaditya Phukon hit on tire with a sword which was carrying. Okhil Gogoi, Jagjit Guhai, Bhaskarjit Phukon, Swargaditya and Bhupen Bora were leading the mobs. Further, I went to state that the leaders from various organizations came to the program separately, but I saw presence of Okhil Gogoi and other KMSS leaders from the very beginning of the program. During that meeting, I got information that some protesters were planning to set fire of the houses of Amravati colony, which is basically a Bengali-dominated area. I got alarmed and informed OC sir immediately to handle the situation. Accordingly, OC sir deployed police party there. So he is a part of the protesters, this gentleman. And he said Okhil Gogoi was present at that moment when they were planning to create problems there. This line is very important. Last paragraph. Further, I want to say the leaders from various organizations came to the program separately, but I saw presence of Okhil Gogoi and other KMSS leaders from the very beginning of the program. During that meeting period, I got information that some protesters were planning to set fire of the houses of Amravati colony. It was done subsequently, a Bengali dominated area. Next, Dhruvo Guhai, next page. He is also a part of the protesters. He also basically said the same thing. PW 31, PWD 32, 33. Now coming to 34. The same day, the railway incident is narrated here. May I read it, Lordship? Kaushik Haldar. On being asked, I state that on 9/12/2019, I had duty from 6 hours to 1800 hours at around 1500 to 1530 hours. Some people came to my office and told me not to allow the train number 15907 Naharlagun Express to come to the station as because they were planning rail roko program and other protest programs in Sabwa. I was newly posted in Sabwa and have lounge problem, so I could not identify any of them. Language pro. I was afraid and nervous and informed the matter to my divisional control, Tinsukia. I asked my great men to know the ground situation, who replied that about 200 to 300 people assembled near the signal so that it was impossible to operate signal for above train. For the safety and security of passengers and me and my staff as well as safety of, I decided to stop the train outside the signal. As long as time passed, during the protesters began to increase in station area as well as near the civil area. Large number of protesters sit on the railway track and observe the rail roko program and by holding banners and shouting different slogans. As I told you already, due to language problem and on newcomer to Sabwa, I could not understand the slogan clearly, nor I could recognize any particular person. Even then, I secretly took the few photographs of crowd in my mobile. It was around 17:45 hours. One meeting was started in railway platform at Tinsukia, in where various leaders from different organizations began to address large number of protesters. Due to my own safety, I could not take photographs of them and unable to recognize any of them clearly. My relief was so and so. So how the things were developing there. Then 35, this camera, these are electronic evidence. Now coming to 41. Statement and witness of Ronak Shah. I am above. I state that I have completed HSLC from Little Angel Schools of Sabwa in the year 2003. I have been working in technical side of Airtel company since 2013. I also do supply business and transportation. I am living with my family, with my mother in the above mentioned address. The address is Lordship, given in the first paragraph. On being asked, I further state that on 9/12/2019, during daytime, when I heard the news of protest program and rail roko scheduled to be held in that evening, led by Okhil Gogoi, KMS leader, and other leaders of several organizations, I became afraid and decided to remain inside my house and keep my other family members to remain inside the home. I also decided not to run my commercial vehicle and park all the vehicles in safe place. I belong from Hindi speaking community and I feel insecure here, and particularly in such situation, there is every possibility that we are victimized in the hand of local people. So for safety, security and my family as well as properties, I decided to remain inside from 9/12/2019 till almost 1 week. From my home, I came to know that violence caused by violent protesters in subway and my neighborhood from TV and other sources. I even saw thick smoke comes in different places and hear the noise of violent protesters in outside. I and my family members were very much afraid during the said period. During that time, I was also prevented family members to go out. So their nearby areas were all burned in that area. So basically the same thing in Jaushad Ali's statement. So these are basically the statements of various witnesses, Lordship, from where we can very clearly discern one thing, that some of the ingredients of section 15 and section 16 are fully complied with. I mean, the presence of ingredients are there, which will be supplemented by the electronic evidence. I have shown some photographs and also the videos. Videos we have not shown, but we have indicated what is the content of the video clips. Now, the telephonic conversation of Okhil Gogoi with various persons. The telephonic media. At this stage, whether a prima facie case is made out or not, that is the core issue.
That is what we had indicated.
Exactly, Lordship. That
At
is
the
what.
time of laying of the charge sheet, those would be the subject matter of a trial after charges are framed and denial is made. But at the time of completion of investigation, whether materials are there to go for a trial on the basis of
Exactly, Lordship.
So on that prima facie satisfaction, it's not necessary for the court at the time of consideration of a discharge application to go into the veracity or otherwise,
Exactly.
because there is no proof, as there is no evidence as such. These are only statements under 161.
161, fine. But it has been supported by the electronic evidence.
That is also, you cannot, these are not evidence. You have to
Yes, whether those statements, we have.
burden will still lie upon you.
Yes,
but,
we have to prove it
yes.
to convict him. Otherwise, he will get acquittal.
But
we have a right to get the materials and the charges to be tried.
Tried. That is
To be tried. And shifting of the evidence at this stage is very minimal. The court cannot enter in depth in the analyzing of the statement. If I am satisfied, if I am capable of satisfying this honorable court or the court below, that a prima facie case is made, it is not a case for acquittal at this stage. Only after trial, the court will decide whether those materials are cogent enough to convict a person, because we follow the principle of beyond reasonable doubt. Whatever the statements given by various witnesses, whether they are sacrosanct, they may be sacrosanct, they may not be sacrosanct, but it has to be tested. It has to be tested. During cross-examination, if they are saying anything wrong or they are lying, it will be exposed. But at this stage, we cannot take a view which is contrary to what is there in the statements. The statement is not of one person. The statements of about, out of 42, about 30 persons are clearly indicating, not less than 30. So there is overwhelming presence of materials against accused number 1, A1. Telephonic conversation. Page number? Lordship will kindly come to 201 of paper book 2. Paper book 1. The telephonic conversation between Ukhil Gogoi and another accused, no, another person, Dhojjo Kaur. He is a functionary of KMSS. The telephone numbers are given. How things are progressing. This is a conversation of 4th December. It started. Here, about 10 lines from top, Ukhil Gogoi said, shall we start rally from Hodia in every village to convince people from 11 December? This was a conversation of 4th December. How things are going ahead. Page 203. Then his conversation with Mridu Pawan Neog of 5th December. Ukhil Gogoi said yes. Then other Mridu Pawan Neog said, today there was a meeting in Home Department that President of India and Japan might not visit Assam on 15 December as everyone was scared that you might create a great nuisance in all over Assam, and I got the information internally. So his colleague was saying that Ukhil Gogoi may be the reason why the Prime Minister of Japan may not visit Assam. Then Ukhil Gogoi asked what they said. Mridu Pawan said, they were discussing that if anything goes wrong in front of both the president, then India will have to face a situation. Next page, Ukhil Gogoi with Jagjit Guhai. Then Jagjit Guhai, I was asking Ukhil Gogoi, Dada, I am Jagjit Guhai of SMSS from Sabua. You said you would come to the protest of Motok Jubo Satra Porikhad on 9 December 2019. Will you come? The answer maybe was not given. Then Lordship will kindly come to page 207. Conversation between Ukhil Gogoi and Paramananda. Ukhil said, yes, Parma, tell me. Then Parama said, on 9 December, Monday at 9 a.m., we will all gather in front of DC office, Jorhat, not on banner of a particular organization, but as Jorhat citizens. We want to show how it is when each and everyone comes out to protest. Ukhil Gogoi said, okay. Then others said, everyone told me Rajiv Gogoi of Atasu was there. Litul will be joining us from the program, and if you will be nearby Golaghat. Ukhil said, actually, I promised to go to Chabua, cancelling all other programs. Then others said, Chabua. Then Ukhil said, they are planning to take big program at Chabua. Then others said, ask target to talk to Rajiv Gogoi. Then Ukhil said, tell me, Rajiv, Dada, be in your program anyhow, as it will be at 9 a.m. Ukhil said, as it is a band on that day, so I already promised to go to Panitola on that day and Sabua at night. At what time will you go? Okhil said, we'll go from Gauhati tomorrow, as after that it is Assam Band. Someone might throw stone on me if I drive on that day. Others said, who will throw stones in your vehicle? Okhil said, people will not know me from far away. Others said, if we get you in Jorhat, it would have been nice. Okhil said, if I had known before, I would have attended it, but now it is not possible, as I have already promised them. If you organize again, then I will surely attend. The next page, Okhil Gogoi, that is a statement of 7th December. Okhil said, I took information today, it will be a good meeting in Sabua comparatively. So the run up to the Sabua meeting. Then Lordship will kindly come to page 210. Others said, Pranab, Okhilda Namaskar, yes, tell me, we have supported the bond tomorrow, and after tomorrow we have declared for half naked program in front of Janta Bhavan. Boys from all districts will be coming for it. What about half naked? Do it full naked, Okhil said. The other said, let's see what can be done at that moment. They might be full naked, as most of the boys are angry. Okhil said, yes, tell me few boys to do it. Have to do something on which day our PM will reach airport. It is on 14 December. Get your peoples ready for it. On that day, there will be black flag and half naked people. All right, I am at Gauhati. Okay, get your man ready. All our people are alert in the 4 directions of Gauhati, and many boys are coming by train. Then Lordship will kindly come to page 212. Okhil Gogoi with Kajal Gohai. The relevant portion will be page 213. This is on 9th in the morning hours. Other said, Kajal Gohai said, okay. Okhil said, being dormant, you have not done good. Lordship will kindly mark this word dormant. Being dormant, you have not done good. Others said, I have not become dormant. Okhil said, no, this is not good. I have come to give some fire to make you warm. I will be on fire now. Okay, come, let's meet. This is on that particular day in the morning. So he wanted to make his colleague warm, and I'll give you fire. So these are electronic evidence.
8:30.
Hmm?
On 8:30.
Then
8:39.
this is at 8:39 in the morning of 9th, when everything is going towards Sabua. Then page 21. Yes, 215. He was talking with Dibbo Jyoti. Sharma, how is the program? Okhil said. Others said, we are in front of the court. How is it? Almost 5,000 people came in. Many are on their way. People are coming. Maybe around 20,000 will be there. Nice, very close, everything totally. It is done totally. Yesterday, we went to every hostel like Agriculture University, JEC, ITI, DCB hostel, JB College hostel, everyone. Very good. Our boys came or not. Others said, yes, saw them. Were you planning to come? Not exactly. I come to Tinsukia as promised. We'll be in Tinsukia, Okhil said. Now we have a meeting in Panitola, Tinsukia. Then we'll have a good program evening in Chabua. Okhil said. Is it? The other said, Okhil said, what you are all doing now there, we'll be doing exactly that in the evening in Sabua. Okay, good. Here in evening, we have a program by Jorhat Students Union. All the organizers students out what? So, presence of Okhil Gogoi at from 6 p.m. onwards. Till that moment also, there were some gathering. But once he entered and once he gave the speech and once he said that, intensify the protest, the things started changing. And there is a drastic change. Then next page. This is important. The previous page timing was at 10 a.m. in the morning, 10:17. Next page at 4:20, 16 hours, 20 minutes, 10 seconds on 9:10. Okhil was conversing with Jogjit. Dada, in Sabha, there will be around 20 to 30,000 people, as 5,000 people already gathered and many are on their way. Okhil said, people started coming. Then others said, there is almost 5,000 people here in Sabha, more than in Panitola. Target, Okhil Gogoi said, okay, then should I come there? Others said, shall I call you when program will start? First you start the program, then call me. So everything was done as per Okhil Gogoi's information and instruction. Next, Okhil Gogoi was conversing with Sanjay. This was 4:46 p.m. 9th. Okhil said, Sanjay da, we have andolans in every corner of Assam. Lakhs of people came on the streets. Railway have been stopped and Assam is totally banned. So what more is required? Railway have been stopped. And he proudly is saying to his colleague, economic blockade, UAPA Act, Section 15 and read with Section 16. So railway have been stopped and Assam is totally banned. So this, in my humble submission, is a clincher, this particular line. And he proudly is saying to his colleague, these are electronic evidence again, not statement of any individual or subjective person. Others said, Sanjay, it is total hurtal. Target Okhil said, yes, people close every corner street of Assam. Others said, very good. When will the bill pass in Rajya Sabha? It will be tomorrow or day after. In Rajya Sabha tomorrow, there is AGP who will support us. Yes, sure. Tell me when it will pass. It will be tomorrow or day after tomorrow. Actually, it will come tomorrow. It will be placed after tomorrow in Rajya Sabha. Sanjay da, if you can kindly send this bill to JPC or make it in standing committee. We'll drop this bill, don't worry. AI is also opposing because it is issue of Tamil Nadu. They are not including Tamil Hindus. Okay, sure, what about? So the remaining part is political dialogues or discussion. The first two lines, which has elements on ingredients of attracting the provisions of UAPA. Next, Lordship, like, then at 5:28 of 9th, running up to the 6 p.m. event, Okhil Goi asking Jogjit, hello, we are on the way from hotel. Others said, okay. Okhil Goi said, how many gathered till now? Till now, almost 7,000 to 8,000 people gathered and many are on their way. Okay, we'll reach in half an hour. What are you doing now? We started the program. Okay, I'm going. So Okhil Gogoi is planning and designing everything to his comrades or his colleagues in KMSS and other organizations also. But he is the leader, and the various person in their statement very clear say he was the chief speaker. So his presence and his role in these activities cannot be ignored, Lordship. What is the final outcome? The program was planned from 4 p.m. 6 p.m. he arrived. He delivered statements. Immediately police were attacked. Vehicles were stopped on the highway. Vehicles were damaged. Led to damaging of the banks, damaging of the railway station, damaging of the circle office and other government offices. Led to attack in one particular community living area. All things followed, and how the run-up was there. We cannot ignore the role. He is the perpetuator here. The game plan was done by him. He executed through he is the leader, and he is the leader, led by, under the leadership of, these are the words used by various witnesses. And from this telephonic conversation, let them deny this. The voice samples were taken, all were examined, It was found to be Akhil Gogoi's version, and the other persons who was on the receiving end or in the conversation, in the telephonic conversations, those were also telling. So how can a court of law ignore all these evidences which are based on scientific materials? It is not a case for discharge at all. We cannot ignore. Out of 42, more than 32 are saying this. All these telephonic conversations are saying this. Photographs are not disputed till date. There is no scope of disputing also at this stage, but at a later stage. But when we have placed the photographs along with that, we have given the required certificates under the law in place. The Information Technology Act 2001, we have followed every requirements. Those were not the grounds under which the Learned Trial Court has given the discharge order. The learned single judge have taken all these statements into consideration, delved into it, shifted all the evidences, and given his final opinion. That is not permissible at this stage. He may do the same thing at the end of the trial. But whether this telephonic conversation between Akhil Gogoi and Jagjit at 5:28 on 9th December 2019, whether it is a statement actually taken place or not, that can be found out in a trial. The learned single judge has no reason to disbelieve this at the stage of hearing the matter on
Not
discharge.
trial court, not learned single judge.
At this stage,
Not learned single judge.
sorry, now he is a learned single judge.
No, we are not concerned with that.
So, my humble submission is that, Lordship, where is the contra view here at this stage? The photographs.
The consideration is whether the materials are sufficient to
Exactly.
go for a
Whether
trial.
a prima facie case is made out or
Whether
not.
it's sufficient to go for a trial
Or
and
not.
to and in adjudicating an application for discharge, a discharge can be made if the materials placed are not sufficient to proceed for a trial.
Even if it is taken on face value,
Face value.
then also no case is made out. Whether all the materials which I have placed from this morning, the other day my colleagues have also placed, whether those materials are sufficient or not at this stage to prima facie believe that a case can be sent for trial. Are they so vague? Are these evidences so unreliable? Any person with a rational mind have to believe unless there is a contra version and contra material on record. That is not there at this stage. I mean, not at this stage, before the learned trial court. At that point of time. And Lordship will also look into these materials from the viewpoint of framing of charge only. Not from the, had it been a case of conviction or acquittal, the Lordship will look into the same materials with a different eye. That beyond reasonable doubt. Now we can doubt it, that this may not be correct. All the statements may be all false. We can doubt it, but we cannot come to a conclusion that these statements or these evidences are unreliable. We can have two views. But to get the other view, Lordship, we have to test it. That testing is not done. Without testing, we cannot say that all these are unreliable, all these are false, all these are manufactured. And different strata of peoples have come and given the evidences. It is not that the government only functionaries were only giving the statements. No. Can that loss of 2 teeth or the damage to his and the injuries, are they not correct? Was he hitting himself with the stone? Where he was hit?
Mr. Borthakur had made one thing clear. His emphasis if the trial is on the aspects of certain offences under the IPC, to that extent.
That is why my whole emphasis is that it is UPA case. It's a fit case for UPA. I would like to place once more. Now the evidences are over.
He says that UPA is
No,
very stringent.
Lordship cannot be so lenient, or we cannot take his.
That is what.
Yes, that is why my whole emphasis. IPC to case is very loud and clear. Whether it is a fit case to be tried under UPA Act or not. So when a professional investigating agency like NIA, whose conviction rate is more than 80%, if they have done the investigation, if it comes under IPC, Assam police could have done it. But as it is a case of national importance, when the planning, because of this telephonic conversation, what was the planning? They want to show dissent before the Prime Minister of Japan. They want to do certain things which will be against national interest before the Prime Minister of India. I'm not talking about who is the Prime Minister or what party he is. It's the country's reputation. So that is why an agency like NIA is involved here. Had Prime Minister of Japan came and India's Prime Minister had a convention in Assam, the scenario of Assam would have been totally different. That is upsetting the interest of Assam as well as national interest. The whole program was cancelled because of all this vandalism. And what is the final outcome? Not even 10 persons have taken citizenship under CAA. I'm not going to give a political statement here, but all these protests were there when it was implemented. What is the final outcome? This is also we have to see. How many persons have taken citizenship under CAA? In the first term, I think one or two applications only had come. This is in public domain. But for that, so many persons, even 5 persons were died, unfortunately. Even Dispur was so badly damaged. Gauhati was damaged. We do not want this kind of things in Assam, and they take proud that we have stalled Assam. A1 in his telephonic conversation. But coming back to the law, Lordship, these are, I do not want to start any political version here. Section 15, once more, I would like to read now with the evidences which I have just placed. Terrorist Act. Whoever does any act with intent to threaten or likely to threaten the unity. Who act with intent to threaten or likely to threaten unity, integrity, security. So when a Bengali dominated area is planned to be attacked, that upsets the unity and security and integrity of our society. Or sovereignty of India, or with an intent to strike terror or likely to strike terror in the people or any section of the people of India or in any foreign country. Number 1, by using bombs, etc. A, last line, or by any means whatsoever nature causes or likely to cause. So by any means. So that speech, that telephonic conversation encouraging his colleagues, etc. By any means. Number 1, death or injury to any person. So the police officer was injured. Loss or damage or destruction of property, railway, forget about Lordship, that railway station. What about the vehicles of the public as well as the police and the ITBP? The circle officer, the bank, are these not public properties? Loss or destruction of the property. 3, disruption of supplies or services essential to the life of community in India, stopping the railways. So that disrupted the services essential to the life of the community. Rajdhani Express was stalled, Kamrup Express was stalled, Naharlagun Express was stalled. So
These-
that,
These have come in these statements.
yes, Lordship, statements. The station master gave his statement. Then Roman 3. Roman 3, I am not. 4. Damage or destruction of any property in India or in foreign. So, in India, in Assam, in Sabwa, in Dibrugarh district, properties were damaged. I am not talking about Gauhati. That was beyond the scope of this case.
Any state government.
Oh dear, sir.
Also.
Hmm.
Any
Yes.
state, any state.
Damage or destruction of any property in India or in foreign country used to intended to be used for the defense of India or in connection with other purposes of the government of India, any state government or any other agencies. So any other agencies here, defense of India, that CRPF and ITBP's vehicle. ITBP's is the Indo-Tibetan Border Force. That vehicle which was flying through that highway to Arunachal, when they are protecting the border with China, that vehicle was stopped when police persons were there. So it comes under Roman 4. Then B says, overawes by means of criminal force or show of criminal force or attempts to do so, or causes death of any public functionary or attempts to cause death of any public functionary. So criminal force has been shown here. Throwing stones, pelting stones.
Even
So
so.
even sword is there. That photograph also I'd like to show. Okay, is there, no?
Present there.
A photograph with A1 and the other person is flashing a sword. Oh, sorry. In the from the meeting, a photograph is there.
80 is there. 80. Accused number 3.
Accused number 3 is there. Page number 2. Lordship will kindly come to page 401. These are procedurally received copies, Lordship. It is not that out of the blue we have annexed these photographs. Everything is technically and procedurally placed in the church seat. 401. 402. The face is visible.
Accused number 3.
It is accused number 3's photograph is 402. He is the accused number 3. Then 403. 402 is the accused number 3. And the sword is there. So all the ingredients which I have just read out, Lordship, in section 15, Terrorist Act, it covers. And section 16 says, whoever commits a terrorist act shall, in such a case, result in a death of any person be punishable with a so and so. So the punishment part is 16. So terrorist act definition and what it encompasses within its domain is given in section 15. So we have to read 16 with 15. So what comprises a terrorist act? So the materials which I have placed, Lordship, in my humble submission is sufficient enough, more than sufficient enough to attract the provisions of section 16 of the UAPA Act. Not speaking about IPC. IPC, Lordship, the other side is already accepting it. So I am happy. I don't have to argue on IPC. Now, what are the laws which are applicable? A recent judgment which compiles all the relevant laws in place, that is State of Gujarat versus Delhi Singh Kishore Singh Rao, 2023, volume 17 SCC, page 688. Paragraph 7 onwards, Lord. Paragraph 7 to 13, I would like to place. Then I will go to three more judgments.
Paragraph 17.
7 to 13.
7 to 13.
Yeah, paragraph 7. On the law points, not on the facts of that particular case, the general principles. It is right law that application of judicial mind being necessary to determine whether a case has been made out by the prosecution for proceeding with trial, and it would not be necessary to dwell into the pros and cons of the matter by examining the defense of the accused when an application for discharge is filed. At that stage, the trial judge has to merely examine the evidence placed by the prosecution in order to determine whether or not the grounds are sufficient to proceed against the accused on the basis of charge sheet materials. The nature of evidence recorded or collected by the investigating agency or the documents produced in which prima facie it reveals that there are suspicious circumstances against the accused so as to frame a charge would suffice, and such materials would be taken into account for the purposes of framing the charge. If there is no sufficient ground for proceeding against the accused necessarily, the accused would be discharged, but if the court is of the opinion after such consideration of the materials, there are grounds for presuming that the accused has committed the offense which is trialable, then necessarily charge has to be framed. At the time of framing of the charge and taking cognizance, the accused has no right to produce any materials or call upon the court to examine the same. No provisions in the code grant such right to the accused to file any material or documents at the stage of framing of charge. The trial court has to apply its judicial mind to the facts of the case as may be necessary to determine whether a case has been made out by the prosecution for trial on the basis of charge sheet materials only. If the accused is able to demonstrate from the charge sheet materials at the stage of framing of charge, which might drastically affect the very sustainability of the case, it is unfair to suggest that such materials should be considered or ignored by the court at that stage. The main contention of granting a chance to the accused for making submission as envisaged in section 227 CRPC is to assist the court to determine whether it is required to proceed with conduct of the trial. Nothing in the code limits the ambit of such hearing to oral hearing and oral arguments only. Therefore, the trial court can consider the materials produced by the accused before the IO. It is settled principle of law that at the stage of considering an application for discharge, the court must proceed on an assumption that the materials which has been brought on record by the prosecution is true, and evaluate such materials in order to determine whether the facts emerging from the materials taken on its face value disclose the evident existence of the ingredients necessary of the offense. It is very important that you have to accept it as true unless it is dispelled during the trial. This court in TN versus TN Surarajan, adverting to the earlier proposition of law laid down by this, we have bestowed our consideration to the rival service that at the time of consideration of the application for discharge, the court cannot, as a mouthpiece of the prosecution or act as a post office and may shift evidence in order to find out or not the allegations made are groundless so as to pass an order of discharge. It is right that at the stage of consideration of an application for discharge, the court has to proceed with an assumption that the materials brought on record by the prosecutions are true, and evaluate the said materials and documents with a view to find out whether the facts emerging therefrom, taken at their face value, disclose the existence of all the ingredients constituting the alleged offense. At this stage, probative value of the material has to be gone into, and the court is not expected to dip into the matter and hold that the materials would not warrant a conviction. In our opinion, what needs to be considered is whether there is ground for presuming that the offense has been committed and not whether a ground for convincing the accused has been a ground for convicting the accused has been made out. To put it differently, if the court thinks that the accused might have committed the offense on the basis of the materials on record on its probative value, it can frame the charge. Though for conviction, the court has to come to the conclusion that the accused has committed the offense. The law does not permit a mini trial at this stage. The defense of the accused is not to be looked at the stage when the accused seeks to be discharged. The expression record of the case used in section 227 CRPC is to be understood as the document and articles, if any, produced by the prosecution. The court does not give any right to the accused to produce any document at the stage of framing of the charge. The submission of the accused is to be confined to the materials produced by the investigating agency. The primary consideration at the stage of framing of charge is the test of existence of prima facie case, and at this stage, the probative value of materials on record need not be gone into. The court, by referring to its earlier decision in Maharashtra, State of Maharashtra versus Somnath Thapa and State of MP versus Mohanlal Soni, has held that the nature of evaluation to be made by the court at the stage of framing of charge is to test the existence of prima facie case. It is also held at the stage of framing of charge, the court has to form a presumptive opinion to the existence of factual ingredients constituting the offense alleged, and it is not expected to go deep into probative value of the materials on record and to check whether the materials on record would certainly lead to conviction at the conclusion of trial. The power and jurisdiction of the higher court under section 397 CRPC, which vests the court with the power to call and examine record of the inferior court, is for the purpose of satisfying itself to the legality and regularities of the proceedings and order made in a case. The object of this provision is to set right a patent defect or an error of jurisdiction or law and perversity which has crept in such proceedings. So my humble submission is that, Lordship, the law is well settled and all the judgment will carry the same principles. And the paragraph 14 very clearly says that Lordship may look into the records once again from the trial court. And Lordship may be pleased to look into whether a prima facie case is made out or not. So the paper book which I have placed is a part of the trial court. And there is at this stage no reasons to disbelieve or ignore any of the materials which the prosecution has placed before the trial court through the charge sheet. Another judgment which I would like to refer to is AIR 1995, Supreme Court 785, State of West Bengal versus Muhammad Khalid. Here I would like to refer to two paragraphs, 78 and 79. Yes, judgment only. 78, 79. Yeah, no, this is 1995. Yeah, no? AIR is AIR 1995 Supreme Court 785. SCC it is 1995 Volume 1 SCC, page 684. Paragraph 78. Coming to taking cognizance, it has been held by the High Court that it was not a recent order. We are of the view that the approach of the High Court in this regard is clearly against the decision of this court in Sri Atyasar Virudhi Parishad case, paragraph 14, which is under. It is in the trial, the guilt of the innocence of the accused will be determined and not at the time of framing of charge. The court therefore need not undertake an elaborate inquiry in shifting and weighing the materials, nor it is necessary to delve deep into various aspects. All that the court has to consider is to whether the evidentiary materials on record if generally accepted, would reasonably connect the accused with the crime. No more need be inquired into. 79. Again, in Niranjan Singh K.S. Punjabi's case, it is stated that again in as superintendent remembrancer of legal affairs West Bengal versus Antique Anita Kumar Vanja, this court observed in paragraph 18 of the judgment as the standard of test, proof and judgment which is to be applied finally before finding the accused guilty or otherwise is not exactly be applied at the stage of section 227, that is discharge, and 2 or 228 of the code of CRPC. At this stage, even a very strong suspicion founded on material before the magistrate, which leads him to form a presumptive opinion as to the existence of the factual ingredients constituting the offense alleged, may justify the framing of charge against the accused in respect of the commission of that offense. So basically, the presumptive opinion is sufficient, or the prima facie opinion is sufficient. State versus S. Selvi 2018-13 SCC, page 455, paragraph 10. State versus S. Selvi, paragraph 10. May I place it?
State versus.
State versus S. Selvi.
Serial number 12 in the note, Lordship. Serial number 12 in the note. It is there in the file.
One paragraph, Lordship. May I just.
Yes. Yes, please.
If on the basis of the materials on record, the court would form prima facie opinion that the accused might have committed the offense, it can frame charge, though for conviction it is required to be proved beyond reasonable doubt that the accused has committed the offense. At the time of framing of charge, the probative value of the materials on record has to be gone into, and the court is not expected to go deep into the matter and hold the materials would warrant conviction. The court is required to evaluate the materials on record at the stage of section 227 and 239 of the code, as the case may be, only with a view to find out if the facts emerging therefrom, taken at face value, discloses the existence of all the ingredients constituting the alleged offense. It is right that at the stage of consideration of an application for discharge, the court has to proceed with the presumption that materials brought on record by the prosecutions are true and evaluate such materials with a view to find out whether the facts emerging therefrom, taken at their face value, disclose existence of the ingredients of the offense. So the part which I have placed today, Lordship, if it is taken on face value and if it is taken that there is no results to disbelief, then all the statements, all the electronic evidences clearly establishes a case under UAPA, section 16. If you take the ingredients which are to be present to constitute a terrorist act under section 15. Aru? একটু ভালো নাকি? 2020-12 SCC, page 467. Dr. Nallapara Reddy, Sridhar Reddy versus State of Andhra Pradesh. Paragraph 25. How can you decide on the veracity of the statements? Oh, they are important case. Have lots about it. Paragraph 25. The veracity of the depositions made by the witnesses. This is very relevant for our purpose. The veracity of the deposition made by the witnesses is a question of trial and need not be determined at the time of framing of charge. So all the statements which I have placed, Lordship, that will be tested at the trial stage, not at the stage of discharge hearing. Appreciation of evidence on merit is to be done by the court only after the charges have been framed and the trial has commenced. However, for the purpose of framing of charge, the court needs to prima facie determine that there exists sufficient materials on for the commencement of the trial. The High Court has relied upon the materials on record and concluded that the ingredients of the offences under section 406 and 420 are attracted. The High Court has spelled out the reasons that have necessitated the addition of the charge, and hence the impugn orders does not warrant any interference. So in that case, the materials placed through the statements of the witnesses made out a case under 406 and 420. Here it is under the section 16 of the UAPA Act. So whether those evidences are finally acceptable or non-acceptable, Lordship, that has to be tested during the trial. But at this stage, if the statements contains the ingredients of the offense, that is sufficient. Sajan Kumar versus CBI 2010. Sajan Kumar versus CBI 2010, volume 9 SCC, page 368, paragraph 19. বাহিৰত বা কি হ'ল এতিয়া আকৌ কি চেঞ্জ হৈ গ'ল পলিটিক্স ডেইলি ইমান চেঞ্জ হৈ আছে ইভলভিং মানে তুমি 3 ঘণ্টা বহুত আপডেট পুৰণা নিউজটো মানে আপডেট ৰাতিপুৱা আপডেটটো ষ্টিল হৈ যাব So paragraph 19, Lordship. It is clear that at the initial stage, if there is a strong suspicion that leads the court to think that there is ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. The presumption of the guilt of the accused, which is to be drawn at the initial stage, is only for the purpose of deciding prima facie whether the court should proceed with the trial or not. If the evidences which the prosecution proposes to adduce proves the guilt of the accused, even if fully accepted, before it is challenged in cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. So here, the statements about involvement of A1 in the offenses under section 16. If we suppose the statements, even if it taken as 100% correct, then also no case is made out. Then it is a case for discharge. Otherwise, till it is rebutted or till it is disputed, during cross-examination in the trial, in that case, Lordship, the case has to be sent for trial. That means it is not a fit case for discharge. Here, all the statements of about 30 witnesses clearly establishes that stand or that materials which are required to be present to make out a case under UAPA. I'm not talking about IPC. IPC is well established. If those statements are sufficient, those electronic evidence, documentary evidence are sufficient, In that case, Lordship, there is no reasons for the trial court to discharge the accused person and close the case for finally. Hello?
Okay, let me see.
2014-11 SCC, page 709, State of Tamil Nadu versus N. Suresh Ranjan, paragraph 29, that the trial court cannot run a mini trial at the stage of discharge hearing. It will be.
Cannot go into deep from the.
এইটো আগতে এবাৰ পঢ়াইছো
এইটো নাই পালো।
ৰঞ্জিত কুমাৰৰ কথা তুমি
Commission of the Rajit Kumar.
We have bestowed our consideration to the rival submissions and the submissions made by
Paragraph number?
29, Lordship. We have bestowed our consideration to the rival submissions and the submissions made by Ranjit Kumar, commend us. True, it is that at the time of consideration of the application for discharge, the court cannot act as a mouthpiece of the prosecution or act as a post office and may shift evidence in order to find out whether or not the allegations made are groundless so as to pass an order for discharge. It is tried that at the stage of consideration of an application for discharge, the court has to proceed with the assumption that the materials brought on record by the prosecutions are true and evaluate the said materials and documents with a view to find out whether the facts emerging therefrom, taken at their face value, disclose the existence of all the ingredients constituting the alleged offense. At this stage, probative value of the materials has to be gone into, and the court is not expected to go deep into the matter and hold the materials would not warrant a conviction. In our opinion, what needs to be considered is whether there is a ground for presuming that the offense has been committed and not whether a ground for convicting the accused has been made out. To put it differently, if the court thinks that the accused might be committed the offense on the basis of the materials on record is on probative value, it can frame the charge. Though for conviction, the court has to come to the conclusion that the accused has to commit the offense. The law does not permit a mini trial at this stage. So basically, we have to look the same evidence from different perspective. At the stage of discharge, it is from one eye we have to see, and from the other eye we have to see at the stage once the trial is over regarding conviction or acquittal. So evidence is at the stage of framing of charge, Lordship, it has to prima facie satisfy the court that a case has been made out. But at the stage of final decision, then the court will have to look it from a different perspective in a more in-depth analysis of the materials. So we have given all the other judgments also with the relevant paragraphs. So basically the repetition, the law has not changed in any manner. We have to see how the Kejriwal's case will be proceeding now. I tried to find out because in that Kejriwal's case, 500 pages judgment is delivered and the accused was given acquittal. Now it is pending before the High Court. Discharge. So the CBI has gone to the High Court. So we'll look into that if any new law is developed there. So this is my humble submission. In fact, Lordship, the learned the trial court judgment, in my view, is totally perverse and non-application of mine and went beyond the area which is permitted to go at the stage of consideration of the charge framing. So in that view of the matter, the said judgment is liable to be set aside and the matter may be remanded back to the trial court for fresh hearing on the point of discharge. Deeply obliged, Lordship.
So we are an appellate court, aren't we?
Yes.
Is it required for a remand? If we,
No, if Lordship set aside,
it
in
will not go for a remand. If we interfere.
Can, Your Lord. Appellate court can.
if Lordship interferes, it will go back.
No, charges will be framed.
Charge will be from either.
Charge will be framed there.
Drill,
Yeah.
there, but it
That
will
is
not go
what, that
for
is what I,
fresh consideration for discharging the,
Lords.
deciding the discharge application.
no, because why I'm saying, because there is another parallel case where the same discharge was given and that order was set aside and it was sent back and fresh hearing had taken place on the point of discharge. But that case, our one of the ground is that we are not fully heard.
That is why it was
But
remanded.
was it an appellate court or a revisional?
It was an appellate court.
Appellate court.
Appellate court, we can
Or
exercise our
appellate court
appellate
feels that
jurisdiction.
since they say had not been heard properly, then send back.
I leave that to your lordship, but I want interference with that order. Deeply obliged.
May I please, Your Lords?
Yes. Mr. Bhattakur, you have, last date, you have almost done your job.
Lords.
If you
Lords.
want to just supplement it. with
Lordship,
anything.
I will supplement it, Your Lordship,
Yes.
in view of what learned senior council has
Yes.
submitted, Your Lordship.
Good.
First of all, Your Lordship will kindly note from the statements that has been read out to this honorable court by the learned senior council, Your Lordship, that the substratum of their allegation is the speech, Your Lordship. During his argument, learned senior counsel has said that he did not do on its own, Your Lordship. That is an admission on the part of the prosecution, Your Lordship. And everything that has happened, a specific word has been used, that this is the offshoot of the instigation given by the accused number one, Your Lordship. These are the two statements made by the learned senior counsel, Your Lordship, on behalf of the prosecution, Your Lordship. Now, Your Lordship, that being the case, Your Lordship will find that all the PWs, Your Lordship, they have not attributed any particular act to the accused number one. And they only said that this is the provocative speech which has resulted in the violence, consequent violence, Your Lordship. Now, Your Lordship will have to go through the speech, Your Lordship, first, because ultimately it is the speech which has created this havoc, these violent activities, this destruction of public properties. Now, in what manner he has instigated, whether it is an instigation or an advocacy of a particular cause, that, Your Lordship, in my humble submission, will have to look into, Your Lordship, prima facie, Your Lordship. Now, therefore, Your Lordship, let us. Your Lordship speech, last occasion I have read out that, Your Lordship.
Speech to legislation.
Your Lordship will get it at page 273. Because this is the speech which, according to the prosecution,
D29.
to D29. Your Lordship, if Your Lordship permits me to read it again, Your
We
Lordship.
have read this, but still, that if you want.
Lordship, since Your Lordship, this argument has come from the senior counsel. May I read, Your Lordship?
Yes, please.
Lords, today the villagers from CM constituency Sabua come out in highway. People from CM's family come out in highway and very clearly tell by the people of Sabua that we don't accept cab, whereas CM tell in this day that cab is a very good thing, and implement of cab, he expressed his gratitude to the PM and HM. At this moment, I think he is taking position in opposite pole of the people, and people of Sabua said that what CM has done, being native of their area, they feel ashamed and there is no other option left for CM to resign him from his post. I think today people of Sabua become example for entire Assam, because in 2016 when the CAP came, where there were large-scale protests in Sabua. Largest number of people came out in Sabua. This time in 2019 also 10,000 people came out at night in the highway in Sabua area and tell clearly that we do not accept cab means by sitting in powers its CM has given up patriotism, but people from his area, people from his village, people from his family said in full voice that we will not give up patriotism. We have to safety our community. We will not give up our land in the hand of foreigner. Therefore, I think CM has no other way left except resign from his post. I think Himanta Biswa Sarma is the most evil politician in Assam and most bad person. Therefore, I don't want to reply of the version of most wicked person. If he wants to see the movement, I wanted to invite him in Sabua. I wanted to invite Himanta Biswa Sarma once leave your Z category CIF persons and come to Sabua to see the movement by wearing color glass of BJP RS and dreaming to get the seat of CM. What kind of speech you delivered, Himanta Biswa Sarma? You betrayed the Assamese community. Therefore, Himanta Biswa Sarma, Himanta Biswa Sarma, Sarbananda Sunwal and Ranjit Datta has been identified as a modern Borphukan by Assamese people. You call Somujjal Bhattacharya if you have courage. Call Akhil Gogoi once. Call me once if you have courage. I am challenging Himanta Biswa Sarma has called Somujjal Bhattacharya for debate. I am so and so challenge you, Himanta. You come for debate of KMSS with me. If he wants to take someone else, Sarbananda Sunwal, take any advocate along with him. I am inviting him for a debate in front of public in cab matter. If he is really one honest politician, if he has courage, he come out and take the challenge. And then your lordship will kindly come to page 275. Next speech, your lordship. My brothers and my sisters, these people from Sabua become an example for Assam. Therefore, I request all of my volunteers, create one human chain in front side by holding each other's hand, create another human chain on back side, and no one will go out from it from the chain even to pass urine without asking the volunteers. What example you have shown? Assamese national organizations could not come together in anywhere in Assam. But here in Sabua, we see in Sabua, the committee of ASU is here also, the committee of KMSS is present today. ASU and KMSS could not come together in Assam, but Sabua has proved that we need to be unified. KMSS, ASU, AJOHP and all other nationalist organizations of Assam and each and every Assam lovers need to be unified and make this movement successful. And the real key for success in our movement, future of Assamese community is the unified movement, yes or no. Therefore, from this platform, I call everybody to be unified. ASU, KMSS, AJYCP, all nationalist organization of Assam, lefty organization of Assam and all political parties unified for the movement against CAB. Until CAB has not cancelled, we will not spare anybody. Now, your lordship, these are the two statements relied on by the prosecution, your lord. Now, from this speech, which is according to them provocative, your lord, is there any material whereby he has instigated the people to commit violence, even to go for rail roko, even to do any violent act? Rather, your lordship has seen, your lordship, from this speech, he is saying that create a human chain and don't go out of that without permission from the volunteers. This is what he has said. Now, ultimately, your lordship, these statements, had this been not there, your lordship, had this statement has not been brought on record, then matter would have been different. Now, everybody, all the witnesses are saying that this is the speech, provocative speech, which has resulted in violence. Now, how to link this speech with the violence? Had he said, then go and sit in the railway line, then we can say that yes, there is semblance of material to link this speech with the violent activities. Now, if your lordship find that every statement from PW1 to PW31 all have been read out to this honorable court, only thing it says, your lordship, that he has instigated. He has instigated. There is nothing more than that through the speech. And I have read out this speech, your lordship. There is not a single sentence in this speech which can be called that can be called as an incitement to violence that had taken place. Now, the learned trial court, your lordship, while considering it, has accepted the materials as that has been placed by the prosecution, has never been raised question about the genuinity or veracity of those statements. But the learned trial court, your lordship, what has found that this speech cannot be considered to be incitement, and therefore this on the basis of this speech, the accused cannot be linked to the violence that had taken place on 10th, 11th, and 12th, your lordship. And 9th, your lordship, will kindly note, your lordship, there is no violence as such, your lordship, when I was there, your lordship. Now, your lordship will kindly come to the volume 2, that there is an FIR, your lordship, lodged by the railway authorities, your lordship. Page 302, your lordship. Now, he is, your lordship, is one of the prosecution witness, your lordship.
Page?
Page 302. This was on 9th, your lordship. And as has been seen from the, your lordship, the evidences, your lordship, brought on record, 161 statements, I was known to all, your lordship. Now, your lordship will kindly see what this FIR says, your lordship. To so-and-so, RPF, subject complaint. I do hereby lodge a complaint to this effect that on 9/12/2019, at about 16 hours, about 1,000 picketers of Nagorikotto Sanshudhani Bidhayok Birodhi Manch under the leadership of Deborshid Setia, working president Sri Dibanjyoti Fukonn, president of Nagorikotto Sanshudhani Bidhayok Birodhi Manch Sabua, resorted to rail roko agitation against Citizenship Amendment Bill 2016. Now, very specific. Who are the persons who have done this, your lordship? Now, these persons are not raised as an accused at any point of time, your lordship. At Sabua station, the agitators obstructed the working of the duty railway servants, that is on duty crew staffs of train number so-and-so, Naharlagun Express, additional SP headquarters, Dibrugarh, SDC Sabua, OC Sabua, PS, IPF, and New Tinsukia, along with staff, attended the spot to control the law and order situation. The above officials severely asked the agitators to leave from the agitation site, but the agitators disobeyed the lawful directions given by the civil and railway administration. The agitators have withdrawn their agitation about so-and-so about 21:05 hours, 9/12/2019. Now, till that time, your lordship, by which time I have already left Sabua, your lordship, there is no violence as such, your lordship. Now, your lordship will see that even in that rail repo, the laws by an officer of the railway, they have not named me, they have named two other persons who led the people. Now, he is PW 26, your lordship.
What has happened to this affair?
Lordship,
What has happened?
that we don't know, your lordship, what has happened ultimately to this affair. But we have not been arrested in this case, your lordship. We have not been arrested in this case. This is lost on 9th after the incident. Everything else, my name is not there, what it points out, your lordship. That I was not there when the rail roko was organized. Rail roko was from 4 and I reached there at around 6 and I left according to the material placed by the prosecution by 7 or 8, your lordship. Now, if something happens thereafter, can it be said that this speech has created the violence? Violence is the outcome of the speech I have made,
Okay, we'll come back.
lordship. Learned senior counsel, your lordship, has pointed out that the entire meeting run up to the meeting, Your Lordship, by relying on the telephonic conversation, Your Lordship, has sought to argue, Your Lordship, that the entire meeting, Your Lordship, and is designed, planned, and orchestrated by the accused number one, Your Lordship. Now, if Your Lordships go through the telephonic conversation again, Your Lordship will find that in those telephonic conversations, there is no statement by the accused number one or the other saying that you go for a strike, you go for a hurtal, you go for a rail roko, you do anything you want to do. These kind of statements are not there. What he has asked one Jagjit Guhai, how many people has gathered. Now, how many people has gathered, this question can be put by anyone going to any meeting. Normally, Your Lordship, leaders, Your Lordship, does not participate in the meeting if gathering is a small one. So, from that statement, can we infer, Your Lordship, that he is planning and designing the whole program? Now, Your Lordship will kindly see PW 30 and PW 31. They are witness brought in by the prosecution, and both of them themselves has says that this is organized by them, Your Lordship. If Your Lordship what has already gone through, Your Lordship, if Your Lordship permits, I want to show it again to Your Lordship. PW 30 and 31, Your Lordship. Okay.
They have said that the meeting has been organized by
By
them.
them and various other organizations. And very interestingly, Your Lordship, in the third paragraph, second paragraph, Your Lordship, in the middle, I am reading, Your Lordship. On being asked, I further state that unlike, it should have been like other organizations under this
You are
umbrella,
on which page?
page 50, Your Lordship, of the
50.
volume 1.
Yes.
On being asked, I further second
PW
paragraph,
30.
Your Lordship,
PW 30.
PW 30. In the first paragraph, he says that he was the general secretary and they have formed an organization. And then second, on being asked, I further state that like other organizations under this umbrella, our organization also took part in various protest programs in different places. When the CAB movement and the CAB about to pass in Rajya Sabha, the movement became more intensified during period of October 2019 till its end. Various organizations, including our organization under umbrella of Nagarikotto Sangshodhani Bidhayok Birodi Mancha 2016, planning for various protest programs including Rail Roko, protest march, meeting, etc. Accordingly, on 9/12/2019, people from local areas start gathering near Chabua railway station and market area at around 5:40 to 6 p.m. Different leaders, Your Lordship will kindly note, from various organizations like ATSA, AJYCP, DYFI, KMS, etc., began to deliver their lecture regarding protest against CAB, where KMS's leader Akhil Gogoi and others also delivered aggressive and provocative speech. In that program, larger number of people come out voluntarily in the meeting place, Your Lordship. Now, if people are coming out voluntarily, there is no question of organizing and orchestrating it, Your Lordship, by a single person. This is their witness, Your Lordship. He himself is saying this, Your Lordship. So to say that I have orchestrated everything, accused number one has orchestrated everything, design, plan, everything, that has not come out from the statement of their own witness, Your Lordship. And similar statement is there by PW 31 also, Your Lordship. Similar, he is also one
If
of the
you read
organizers.
further, Mr. Bhattapur,
Lordship,
please read further.
Lordship, as per my knowledge, no permission from civil authority was taken
No,
for
prior to that, in that program, larger students were voluntarily due to which road was
due to
disrupted.
road traffic was disrupted by along with others, organizers try to clear the highway.
The program of Rail Roko was there.
Program of Rail Roko was there, and that is by them, Your Lordship. And Your Lordship has seen from the statement of the FIR of the OC, FIR of the concerned railway officer, Your Lordship, as well as the statement, Your Lordship, from some of the railway officer. They have categorically named that this organization and these two persons, one Dibon Chandra Phukon and Deborsi, Your Lordship, they are leading the Rail Roko. So far as my role, Your Lordship, in the Rail Roko is not there, Your Lordship. not have been attributed to me, Your Lordship. And in the speech, Your Lordship has found, Your Lordship, I have not asked for this speech, Your Lordship. At best, Your Lordship, this is not a dissent speech, Your Lordship. The public decency does not conform to the public decency, Your Lordship. A leader, Your Lordship, should maintain, Your Lordship. That may be there, Your Lordship. But for that, any criminality can be attributed to this speech, Your Lordship, to make it an offensive speech, Your Lordship. Next page, Your Lordship, PW 31, similar statements, Your Lordship. Exactly similar statement. He belongs to CPIM organization, party, and he again says that people came out voluntarily, and Akhil Gogoi and others also delivered, Your Lordship, aggressive and provocative speech. In PW 38, page 52, Your Lordship, PW 31. Now he says that there are other persons who also gave provocative speech.
Yes.
On the face of it, Your Lordship, even we accept all these materials, Your Lordship, that will have to be a very cogent, Your Lordship, reason for framing charge, Your Lordship, with this kind of, Your Lordship, materials, Your Lordship. And Your Lordship will kindly see, for a moment, Your Lordship will kindly come to PW 18, Your Lordship, page 32. In the middle, there is a statement, Your Lordship. There is a sentence, Your Lordship. The meeting was arranged near Sabua rail station. As soon as the Akhil arrived, he asked people to sit on the railway track to block the rails. Now, is there anything on in his speech, Your Lordship, asking people to sit in the railway track, Your Lordship? They have captured videos, Your Lordship, that has been brought on record, Your Lordship. That statement is now nowhere there. And interestingly, Your
See,
Lordship,
there are
Lordship.
two definite statements. As soon as so-and-so arrived, he
Lord.
asked the people to sit on the railway track to block the rails. This may not be essentially be a part of the speech. See the next line. After some time,
Lordship.
while the provocative lecture of so-and-so was going on.
Lordship. No, what
So
I
after
have,
coming, the speech may not start when he enters the
Lordship.
arena.
Lordship, that is why, Your Lordship, that would have been, Your Lordship, because
So
Your
these would be
Lordship,
matters of proof. Burden is upon the prosecution.
no, Your Lordship, that is why, Your Lordship, because Your Lordship, some of the witnesses are saying, Your Lordship, that even before I reached, Your Lordship, the rail roko has started, Your Lordship. It is from 4 something.
So will it be a case that there are no materials even to proceed?
So far as, Your Lordship, these parties.
No material sufficient. The word is sufficient.
Yes, Your Lordship. Not there is no sufficient material to proceed against this under section 16 of the UAPA Act, Your Lordship. That is my submission, Your Lordship. 326 may come, Your Lordship. Someone getting injured, officers getting injured. 353 may come, Your Lordship. By using criminal force, some public officials are not allowed to discharge their duties. But for terrorist act to be attracted, Your Lordship, something probably more will have to be brought in by the. We cannot, based on conjectures, Your Lordship, and presuming things, putting words in his mouth. Can the Honorable Court can frame charge against an accused person, Your Lordship? Ultimately, Your Lordship, it will have to be a grave suspicion.
One bowler also demonstrated because of the instigation. কিমান দূৰ এইখিনি প্ৰমাণ কৰিব পাৰে নহয় সেইটো বেলেগ কথা হ'ব এইটো মেটেৰিয়েল নাই বুলি ক'লো লাষ্ট পাইছানে
And in fact, Your Lordship, in this statement, Your Lordship has gone through a witness saying that the person should be taken into judicial custody, Your Lordship. At least, Your Lordship, I have never heard a witness, I've never seen any statement by witness against any person saying that before police that it should be taken to a judicial custody, Your Lordship. This creates serious doubt about this. But still, Your Lordship, we will have to accept it since, Your Lordship, we cannot.
Which one? Who is that?
This witness, Your Lordship, Biswajit Phukon. He says Akhil Gogoi is an influential person and can provoke crowd by his strong voice. It also seemed that soon after the arrest, then judicial detention of Goya, some neutral witnesses acquainted with the facts of so and so. He is suggesting, Your Lordship. Your Lordship. Lordship, it will be with them. They can, Your Lordship, provide it.
We have.
Lordship can do it.
No difficulty. No difficulty.
Lords. Lordships can always.
আছে engage?
Our presence may not be required. Your Lordship can go to Lordship. We have Your Lordship faith on this on our board. No need to.
Or if required, you can display it here also.
That will not-
These are in public domain. These speeches.
But when
No, no difficulty. What I am saying.
Lordship, Lordship. Now, your lordship can kindly see the learned senior counsel has relied on your lordship page 279. You know. And in a statement, your lordship, in a video, your lordship, in this clip, Okhil Gogoi is welcoming the protesters and saying that the fire would be spread, your lordship. Now, your lordship will kindly see that during some agitation, there is a slogan, "Ei jui jolise jolibo," your lordship. Now, this is very common. This is very common in any, your lordship, movement, any program, these kind of slogans. These are rhetorics, your lordship. More than that, nothing can be attributed to this, your lordship. That, your lordship, can we go beyond the, your lordship? Can we take it so literally, your lordship? To say that this is what he wanted to do. Lordship. 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 Instigating for what, your lordship? Ultimately, that is the issue. Instigating to do something, to commission certain act, to commit an offense, whether that is there or not, your lordship. That is the only question, your lordship, the learned trial court, your lordship, has looked into, your lordship. And I will show from the judgment, your lordship, of the learned. No, your lordship, that is why I am saying, your lordship, there is no material to connect me with those, your lordship, because, your lordship, whole substratum of their allegation is that my speech has, your lordship, created this situation. Now, if we then, your lordship, from the speech itself, there will have to be some link with the act. One person saying that one person is asked by police, have he asked the people not to throw stones? He is saying not, he has not. Now, can we draw an inference that since he has not asked, he has instigated? That cannot be, your lordship. That will be too far-fetched, your lordship, to hold that this is an instigation, not asking anyone to act. Lordship. Therefore, your lordship, in my humble submission, your lordship, these materials is not enough to create grave suspicion. There may be suspicion, your lordship, and there may be grave suspicion. Only when there is a grave suspicion, the honorable court, your lordship, trial court will frame charge, your lordship. Mere suspicion, there will be no framing of charge. This is the law laid down by the honorable apex court, your lordship. Before that, your lordship will kindly see the judgment of the learned trial court, your lordship. Page 135, your lordship, of the volume 1, the judgment, your lordship. Page 135, your lordship, analysis of materials, your lordship. Other rest, your lordship, the first part is, your lordship, what the witnesses have said. Page 46, para 46 onwards.
Yes, very important.
Can I open it?
May I read your worship? May I read your worship? Witnesses like witness number 5 to 8 have stated that the crowd led by Akhil Gogoi started pelting stones in the police party, but some other of the other witnesses have stated that Akhil Gogoi delivered an aggressive and provocative speech, and subsequently some members of the crowd started pelting stones in the police party. Therefore, I find some difference in the nature of the incident narrated by these two sets of witnesses. Further, several of the witnesses have stated that they could not recognize the protesters who had thrown stones on the police party, leading to injuries on OC Sabua police station. Now, a statement of the witness Devorki Setia that the accused persons, including A1 leading the mobs, is not corroborated by similar statements on the part of the witnesses about the accused persons leading the mobs. Further, some of the witnesses attributed vandalism on the part of protester instead of attributing to it to A1. Some of the witnesses have also stated that they do not know the attacking person, and some other witnesses have stated that they could not recognize the attacking persons in the dark. There are statements, Your Lordship, I can show that. Some witnesses have simply stated that some protest in the crowd pelted stones. In the context of the statement of few witnesses that A1 gave provocative speech to the crowd, which turned violent, the content of the speeches available in the document D29 is most important to correlate the two. In this regard, upon perusing the speeches of A1 from D29, I find that though it contains some sharp political statements and criticism with regard to CAP, there is no incitement to violence. I also did not find incitement, instigation to damage property or obstruct public officials. Considering content of the speeches available in D29 and statement of the witnesses about provocative speech, it appears that the tone, tenor of the speech might have been aggressive on the issue of CAP rather than the speech directly inciting violence. After noticing the contents of the speech A1 from D29, I find a contradiction with statement of one or two witnesses about A1 leading violent mob throwing stones. If the contents of the speech of A1 do not contain instigation of violence, etc., simply the statements by some of the witnesses about A1 giving provocative speech leading to violence could not relied on in my considered view to impose criminal liability on A1. In the large gatherings where speeches are delivered on contentious issues, it is possible for the crowd to get excited. Some unruly elements therein might take undue advantage of the situation to indulge in unacceptable behavior. The omission on the part of A1 is revealed by the statement of some of the witnesses that after some vandalism started, he did not do anything to stop it. However, in my considered view, that in itself would not impose criminal liabilities on him, though he might have been his moral responsibility to try and do something about it. Now, Your Lordship, in holding that, Your Lordship, the learned Honorable Trial Court, Your Lordship, has never gone beyond what is permissible for a judge to consider in consideration of charge, Your Lordship. Because Your Lordship simply trying to Lordship, that this person instigated. And as a result, this has happened. And it is their case that I have not participated in that. I only instigated. Now, who have participated? Where are they? Unless you bring them, unless you brought them either as a witness, bring them either as a witness
But
or
the
a-
door is not completely closed to arraign somebody as an accused at the stage of the trial.
that can be your
That
lordship.
can be.
That can be, but at this stage, this is an
There
important
are
question.
stages
Your
where you
lordship.
can have new accused persons, give notice to them, and you can proceed.
No, but your lordship, for that, your lordship, now what kind of investigation is this, your lordship? That some terrorist act has been committed by person at my instigation, I was arrested, I was detained, in spite of having all the footage, etc., the actual perpetrators of the crime, they are not. Before the neither had one of such person had said that yes, Akhil Gogoi has asked us to do this, then my case is completely gone, your lordship. But there is not a single material is there, your lordship, so far as that aspect is concerned, your lordship. And in fact, your lordship, the learned trial judge, your lordship, while passing the judgment, your lordship, has not all are acquitted, discharged, your lordship. So far as one is concerned, Bhaskarjit Phukon, charges are framed against accused A3 Bhaskarjit Phukon and so under section 144 and 148 of IPC, your lordship, and he was directed to appear before the CJM Dibrugarh, your lordship. To say that there is non-application of mind, your lordship, on the part of the trial judge in my humble submission is absolutely incorrect, your lordship. He has applied his mind, your lordship, and has not gone beyond what is permissible and arrived at a conclusion, your lordship. To have a different view, your lordship, something more will have to be brought on record, which he has not considered, your lordship. What is that more, your lordship, which he has not considered, your lordship? Everything shown by the prosecution, your lordship, today before this honorable court has been dealt with by the learned trial court, your lordship. Telephonic conversation, everything, your lordship, and have give his finding, your lordship. Had it been a case that these are the aspects has not been considered by the learned trial judge, your lordship, yes, then they can have a case, your lordship. And your lordship will note one other aspect, your lordship.
Yes.
Your lordship, that darkness part, your lordship, that one of the driver, your lordship, Kondopan, PW 23, page 41, he has said that, your lordship, that due to darkness and there was huge crowd, I could not identify any of the protesters clearly. That has been, your lordship, referred to by the learned honorable judge, your lordship. So therefore, your lordship, in my humble submission, the judgment delivered by the learned trial judge, your lordship, is is absolutely within the bound of law, your lordship, and he has not gone beyond the permissible limit while your lordship, while considering or sifting or weighing the evidences, your lordship, placed by the prosecution side, your lordship. And so far as the judgments relied on by the learned senior counsel is concerned, your lordship, there cannot be any quarrel on the position of law that has been settled by the Honorable Apex Court, your lordship. To what extent a judge can go, your lordship, trial judge can go, your lordship, while considering charge, your lordship. In fact, your lordship, I am also relying on few judgments, your lordship, if your lordship permits me.
Yes, yes, please.
Before that, your lordship, kindly take up the UAPA for a minute, your lordship. Now, what is the purpose of UAPA, your lordship? Your lordship may kindly see the preamble of the act, your lordship. Why this has been brought in, your lordship? May I read, your lordship?
Yes, please.
An act to provide for more effective prevention of certain unlawful activities of individuals and association, and for dealing with terrorist activities and for matters connected therewith. Whereas the Security Council of the United Nations in the so-and-so meeting adopted regulation so-and-so on 28 September 2001 under Chapter 7 of the Charter of the United Nations, requiring all the states to take measures to combat international terrorism. Your lordship will kindly note that. Then, and whereas resolution number so-and-so, 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 and so-and-so of the Security Council of the United Nations require the states to take action against certain terrorists and terrorist organizations to freeze the assets and other economic resources to prevent the entry into or the transit through their territory and to prevent the direct and indirect supply, sale, or transfer of arms and ammunition to the individuals or entities listed in the schedule. And whereas the central government in exercise of powers conferred by Section 2 of United Nations so-and-so has made prevention of suppression of terrorism resolution so-and-so, and whereas it's considered necessary to give effect to the said resolution. Now, your lordship, these amendments that has come, your lordship, subsequent to this, and your lordship, it has a, and this is a situation, your lordship, where international terrorism, more particularly the terrorism that we have been witnessing, your lordship, India is also a victim of such terrorism, your lordship. About that, your lordship. Now, in every case, your lordship, even pelting of stones, if you try to impose, your lordship, bring in UAPA, that is not what envisaged by the act, your lordship, legislature, your lordship. Now, your lordship, therefore, your lordship, my submission, your lordship, with regard to humble submission with regard to section 15, your lordship, is with utmost humility in my command, I am submitting, your lordship, that your lordship, this 15, context of 15 is completely different, your lordship. And for attracting 15, there will have to be 3 ingredients will have to be present. And 3 ingredients are, your lordship, 15.1, then 15.1a, means, intent, means, and consequence. At the same time, when 3 ingredients are present, only this can be called an terrorist act, your lordship. If one is absent, your lordship, then it cannot be called a terrorist act, your lordship. Now, means, your lordship, it says, your lordship, that your lordship may kindly see, means, by using bombs, dynamite, or other explosive substances or inflammable substances, or firearms, or other lethal weapons, or poisonous or noxious gases, or other chemicals, or by any other substances, whether biological, radioactive, nuclear, otherwise, of a hazardous nature, or by any other means. Now, the kind of, your lordship, means this says, your lordship, this is not, your lordship, stone cannot be brought into this, your lordship. Simply throwing a throne, your lordship, that by any other means we cannot expand it to in that way, your lordship, so much, your lordship, that anything can be brought under this, your lordship. What is the means, your lordship? And your lordship will kindly see, your lordship, that by any other means will have to be interpreted by applying the principle of your adjustment generis, your lordship. Your lordship. And for that, your lordship, I am relying on a judgment, your lordship.
But is it only confined to use of pelting of stones causing hurt, grievous hurt to an officer? What about causing loss to damage to public property,
Lordship,
railway,
that is your lordship. After,
bolero?
that is not on 9th, your lordship.
No, 9th, the bolero was overturned.
Bolero was overturned, your lordship, but can it be it be called, your lordship, that that by any other means your lordship, ultimately, your lordship, it can be tackled by normal penal laws, your lordship.
These are the factors, including a very great other means.
All of the like নহলে এবাৰ কলে একদার মাটি কোথাও নাই পুরা মুজি
এটাই হেকো উপর আমি ভোটিং no all this or overall so payment folks are better attempts to do shit what is there to often the good demos avoids and once the damage
last night but that last night ready for them in terms of blame
Lordship. Therefore, your lordship, if permits me to
yes please
that's your lordship 1989 2 SCC 458 euros. Siddheswari Cotton Mills Private Limited, your lordship. 1989 2 SCC 458. Para 12 and 20 euros. Para 12 and 20. May I read 12 your lordship? The expression "ajus them generis" of the same kind or nature signifies a principle of construction whereby words in a statute which are otherwise wide but are associated in the text with more limited words are by implication given a restricted operation and are limited to matters of the same class or genus as preceding them. If a list or string of or family of genus describing terms are followed by wider residuary sweeping up words, then the verbal context and the linguistic implications of the preceding words limit the scope of such word, your lords. Now here, if your lordship sees the means described by the preceding words, your lordship, this bomb in firearms and other lethal weapons, poisonous, noxious gases, etc. your lordship. Then para 20, your lordship, it says in respect of that this particular case, your lordship, dealing with. In the present case, the expression bleaching, mercerizing, dyeing, printing, and waterproofing, rubberizing, shrink proofing, organized processing, which precedes the expression or any other process. Contemplate.
Mr. Bhattakur,
Lordship.
my brother has just pointed out one thing.
Lordship.
You are confining your argument on 15A.
Lordship.
15(1)(a).
Lordship.
15(1)(a) uses the expression by any other means.
Lordship.
And in that context, you are trying to bring in the submission of usedom generis. But there are two other independent provision,
Lordship.
namely B and C. A has got 1, 2, 3, 3A and 4. There are 5 subheadings
Lordship.
under A, but B is independent.
Lordship.
B does not talk about any means.
Lordship.
See,
No.
see the expression used in B,
Lordship.
overall by means of criminal force. That is independently an offense. Or it has got nothing to do with causing death. Or the show of criminal force, that itself, or attempts to do so, or causes death of any public functionary, or attempts to cause death of any public functionary. So here, so far as B is concerned, the use of the expressions bombs, dynamite, so and so, and any other means may not come.
Lordship, my humble submission, your lordship, subject to what your lordship had.
Because A, B, C, and are all independent.
Lordship.
Parts of section 15.
Your lordship will kindly see whoever does any act with intent to threaten or like this will remain one.
Yes. Only one obviously is
Threaten
the section.
unity, integrity, security, economic security, sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people of India in any foreign
Or
country,
in any foreign country overall.
by means of
So-
that intent, your lordship.
Yes.
That is there, your
Yes.
lordship. Now your
Overall.
lordship will kindly see, or the show of criminal force or attempts to do so or causes death of any public person, attempts to cause death of any public or details. This C will not come, your
She will
lordship.
not come.
Now, your lordship, B, even if it B, your lordship, we consider it as an independent, even then, your
No,
lordship,
we are not considering. That is the purpose of the
Lordship.
statute. It's an
Lordship.
independent.
even then, your lordship, I will not come within this, your lordship, because there is no material, your lordship, to show that your lordship. Now,
No, this we have pointed out because you are arguing that
Lord.
the use of expression by any other means,
Means,
that is not there.
not there.
So then you have to fall back on B.
Charge sheet. Lordship. But their case is that, your lordship, in the charge sheet, your lordship will kindly see. কিমানত আছিলে charge sheet? নহয়। তাকে। Hmm? Anyway. Lords, in the your lordship charge sheet, they have said your lordship A1 delivered provocative speech at this spot in the Chabua, which has caused disruption in public peace and damage and destruction of public and private properties and disruption of services essential for life of community in India and create a fear in a section of people in India, which is a terrorist expert, section 15(1)(a), 2, 3, and B, your lordship. B is there, separate. It is there. But even then, your lordship, even if we consider this as an independent, your lordship, even then, your lordship, there will have to be some, so far as 15(1)(a)(3), your lordship is concerned, that will be my submission, your lordship. And so far as B will be concerned, your lordship, even if it will look at it as an independent provision, your lordship, even then, your lordship, materials are not there for framing of charge, your lordship. Then your lordship will kindly note, your lordship, that two judgments, your lordship, on discharge, your lordship, that I am relying on charge framing, your lordship. One is, your lordship, 1979 3 SCC 4, your lordship, Somal. Profulla Kumar Somal, your lordship. Para 10 I am relying on. Para 10 may I read, your lordship? Just what the honorable court has held, your lordship. Thus, on a consideration of the authorities mentioned above, the following principle emerges. That the judge, while considering the question of framing of charge under section 227 of the code, has the undoubted power to sift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. Then, where the materials placed before the court discloses grave suspicion against the accused, which has not been properly explained, the court will be fully justified in framing charge and proceeding with the trial. 3. The test to determine a prima facie case would naturally depend upon by facts of each case, and it is difficult to lay down a rule of universal application. By and large, however, if two views are equally possible and judge is satisfied that the evidence produced before him while giving rise to some suspicion.
This has been reproduced in the SLV.
Lordship.
18 case.
Lordship.
18.
Lordship.
Profulla has been taken into
Lordship.
consideration.
This
If you
is-
read paragraph
yes.
6,
Lordship.
this court has, after Honorable Supreme Court, after discussing all the case
Lord.
laws, including Profulla Samal, if you have Selvi, you can read paragraph 6.
Lordship.
Same expressions have been
Lordship.
used. We have read this.
Lordship.
Paragraph 6.
This is, your lordship, I am relying on, and then, your lordship, another, your lordship, para 16, 2008, 10 SCC 394, Jogesh, your lordship. Para 16, your lordship. It has, your lordship, reiterated what Samal has said, your lordship.
Yes.
Para 16, your lordship, I will not read it again.
Of which Yogesh.
Jogesh, your lordship. It has reiterated the principle laid down in, your lordship. Samal.
Profulla.
Profulla Samal. Para 16.
Yogesh is 2008, I think.
2008, 10 SCC, your lordship.
Profulla was paragraph?
Profulla para 10, your lordship. Jogesh para 16.
16.
And, your lordship, this, your lordship, on terrorist act, your lordship. This is a case, your lordship, 1994 4 SCC 602. Etu dasu. Hitendra Vishnu Thakur. This is case, your lordship, relating to TADA, Your Lordship. TADA has a, Your Lordship, definition of terrorist act akin to the, Your Lordship, UAPA, Your Lordship. UAPA has been amended after TADA was struck down by the Honorable Apex Court, Your Lordship. Now, para 15, Your Lordship, may kindly permit me to read it. Does the true ambit of section 3(1). Now, Your Lordship will before that.
But
Para 4,
Hitendra Vishnu is famous for another aspect,
Lordship.
mandatory period.
Lordship. It is, in this case itself, it has been dealt with.
That is why.
Lordship.
What would be the last date?
Lordship.
In TADA 180, other
Lord.
cases either 60 or 90.
Lordship. Para 4 is, Your Lordship. The Honorable Court has reproduced the section 3(1) of TADA. Then, Your Lordship, para 15. Thus, the true ambit and scope of section 3(1) is that no conviction under section 3(1) of TADA can be recorded unless the evidence laid by the prosecution establishes that offence was committed with the intention and purposes under section 3(1) by means of the weapons, etc., as enumerated in the section, and was committed with the motive as postulated by said section. Even at the cost of repetition, we may say that where it is only the consequences of the criminal act of an accused that terror, fear, or panic is caused, but the crime was not committed with the intention as envisaged by section 3(1) to achieve the objective as envisaged by the section, an accused should not be convicted for an offence under section 3(1) of TADA. To bring home a charge under section 3(1) of the Act, the terror or panic must be actually intended with a view to achieve the result and envisaged by the said section, and not be merely on incidental fallout or consequence of criminal activity. Every crime being a revolt against the society involves some violent activity which results in some degree of panic or creates some fear or terror in the people or a section thereof, but unless the panic, fear, or terror was intended and was sought to be achieved, either of the objectives as envisaged in section 3(1) of the offence would not fall stricto sensu under TADA. Therefore, as observed in Carter Singh case by the Constitution Bench, section 3 operates when person not only intends to overthrow the government or create terror in people, etc., but he uses the arms and ammunition which results in the death or is likely to cause death and damage to property, etc. In other words, a person become a terrorist or guilty of terror activity when intention, action, and consequences, all three ingredients are found to exist, Your Lordship. And Your Lordship will it is only to
Yes.
Lordship, one more judgment I am relying on, your Lordship. Para 8 of 1994 SCC 76, your Lordship.
1990.
94 SCC, Niranjan Singh, Karam Singh, Punjabi versus Jitendra Kipraj
1994.
Para 8. It is on, your Lordship, how to interpret penal statute. Your Lordship knows very well. For my satisfaction, I have listened this, your Lordship. It is also in respect of a case under Tada, your Lordship. May I read Para 8, your Lordship? The Act is a penal statute. Its provisions are drastic in that they prove minimum punishment and in certain cases enhanced punishment. Also.
Paragraph 8.
Paragraph 8, your Lordship.
Okay.
Make confessional statements made to a police officer not below the rank of superintendent of police admissible in evidence and mandates raising of a rebuttable presumption on proof of facts stated in clause A to D of subsection 1 of section 21. Provision is also made in regard to the identification of an accused who is not traced through photographs. There are some of the special provisions introduced in the Act with a view to controlling the menace of terrorism. These provisions are a departure from the ordinary law, since the said law was found to be inadequate and not sufficiently effective to deal with special class of offenders, including terrorist and disruptive activities. There can therefore be no doubt that the legislature considered such crimes to be an aggravated nature which could not be checked or controlled under ordinary law and enacted deterrent provisions to combat the same. The legislature therefore made special provisions which can in certain respects be said to be harsh, created a special forum for the speedy disposal of the cases, provided for raising a presumption of guilt, placed extra restriction in the regard to the release of the offenders on bail, and made suitable change in the procedure with view to achieving its objects. It is well settled that statute which imposes a term of imprisonment for what is a criminal offense under the law must be strictly construed. In Usman Bhai Daud Bhai Memon versus State of Gujarat, this court in paragraph 15 of the judgment observed as under, the Act is an extreme measure to be resorted to when the police cannot tackle the situation under the ordinary penal law. The intent is to provide the special machinery to combat the growing menace of terrorism in different parts of the country. Since, however, the Act is drastic measure, it should not ordinarily be resorted to unless the government's law enforcing machinery fails. To put it differently, the ratio of the decision is that the provision of the Act need not be resorted to if the nature of the activities of the accused can be checked and controlled under the ordinary law of the land. It is only in those cases where the law enforcing machinery finds the ordinary law to be inadequate or not sufficiently effective for tackling the menace of terrorist and disruptive activities that resort had to be to the drastic provisions of the Act. While invoking criminal statutes such as this Act, the prosecution is duty bound to show from the record of the case and documents collected in the course of investigation that facts emerging therefrom prima facie constitute an offense within the letter of the law. When a statute provides special or enhanced punishment as compared to the punishment prescribed for similar offenses under ordinary penal laws of the country, a higher responsibility and duty is cast on the judge to make sure there exists prima facie evidence for supporting the charge leveled by the prosecution. Therefore, when law visits a person with serious penal consequences, extra care must be taken to ensure that those whom the legislature did not intend to be covered by the express language of the statute are not roped in by stretching the language of the law, Your Lordship. In my humble submission, Your Lordship, what the learned trial judge did, Your Lordship, did not stretch the language, Your Lordship, and thereby hold that the alleged act will not come within the ambit of section 15, Your Lordship. One more judgment recent, Your Lordship.
This section will introduce the ways to study what we see. Which over time, it's like this, and it will be available. Like the difference between, the difference between.
Litigation between Harlow.
It's this. We can get only one from that. Standard case.
আধা ঘন্টা করে তুমি 2 ঘন্টা লাগাও ফিস দিয়ে দেবো
এটা আরো না
What is Vernon?
Vernon, Your Lordship has reiterated the earlier judgment, Your Lordship, at para 45. I will not read it, Your Lordship.
There are 35.
Para 45, Your Lordship.
ওই গলি
হয়ে গেল, এটা আছে আমার। And one judgment is there, Your Lordship, that has been extensively relied on by the learned trial court, Your Lordship. That, Your Lordship, I will not read it, Your Lordship. He has recorded it. The para 48 onwards, Your Lordship, of this judgment, Your Lordship. This is from Delhi High Court Division Bench, Your Lordship, for persuasion, Your Lordship, not more. So in my humble submission, that's only para 48 onwards, Your Lordship. Learned trial court has relied on it, Your Lordship.
statement 132 দেখাল আর 18 দেখাল
In fact, Your Lordship, learned trial court, Your Lordship, while considering the case, Your Lordship, relying on a judgment is Watali, Your Lordship, has for the judgment has clearly held, Your Lordship.
In this Asif Iqbal, which paragraph?
Para 48 onwards, Your Lordship. Up to 60 onwards. Judgment to policy. No. Yes, here this is IPC 326 to 152 yes. Lordship. Now, your Lordship, so far as these if your Lordship comes to page 112 of the volume 1, the Honorable Trial Court, your Lordship, has mentioned about the standard phase, your Lordship, in granting a framing charge and bail, your Lordship. Now, in the case of Nia versus Zoru Ahmed
Watali case.
Watali has said, your Lordship, that degree of satisfaction to be recorded by the court for opining that there are reasonable grounds for believing that the accusation against the accused is prima facie true for the purpose of adjudicating bail is lighter than the degree of satisfaction to be recorded in considering a discharge application or framing of charges in relation to offence under 1967 Act. Thus, for framing of charge, a higher degree of prima facie satisfaction is necessary than one required for the purpose of deciding question of bail. Higher degree will be required for framing of charge. And going by applying that principle, your Lordship, the learned trial court has passed the order, your Lordship, discharging the accused person. And in fact, your Lordship, my humble submission will be, your Lordship, so far as the other offences are concerned, 326, 307 are there, your Lordship. Now, unless I myself commit the act, your Lordship, 326 will not come. Even my speech has caused that, then, your Lordship, I will have to be at best abatement, your Lordship. But that charge is not there, your Lordship.
149 is not there.
149 is there, but
Then-
your 149 is there, but so far as this 326 is concerned, 149 can bring me, your Lordship, within that.
149 is
But
there.
the for your Lordship making me, your Lordship, that 326, your Lordship, that since it is a particular person has thrown this stone, a particular stone,
That argument will
Lord.
be wholly rehearsed to one, we'll be forgetting 149.
Lordship.
149 is
What
there. Why are you
49 will
making this
bring, your
argument?
Lordship, no doubt about that, your Lordship. That is there. And secondly, your Lordship, so far as the other accused persons are concerned, your Lordship, same argument on my part, your Lordship.
How many accused are there here?
4, your Lordship.
Four.
And
The appeal is against 4 persons.
yeah,
3 have been discharged.
discharge, your Lordship.
1 has been charged under.
Charged under 147 and 148, your Lordship. Now, your Lordship, that is what I am submitting, your Lordship, that so far as it is not that no one has been charged, the material found against whom, to that extent, the learned trial court, your Lordship, has framed charge, and that shows the application of mine by the Honorable Court, your Lordship. Therefore, in my humble submission, there is no error on the part of the learned trial judge while discharging the accused persons, your Lordship. And the order is, Lordship, the judgment and order passed by the learned trial judge is not required to be interfered with by this Honorable Court. This is my submission.
One thing is troubling me now, Lordship, because initially it was accepted that he can be tried under IPC. Now the stance has been changed. So if that argument I will have to make, then I will argue whatever he has replied now to those points. But if they are still not exceeding or conceding IPC, then I will have to pray for 1 day's time to make my arguments on IPC, because that will consume a lot of time. Because my understanding was that IPC, they have accepted. Lordship was also pleased to say the same thing the other day, and today also during my submission.
No, Mr. Saikia, whether he accepts or not,
That is,
ultimately.
No,
we'll
if
take
they
a call.
concedes, then I don't have to make argument. If the other side concedes that, okay, UPA is not applicable, IPC is applicable, then I do not have to argue on IPC, because this is not a case before the trial court. It is
Correct.
only for the purpose that only a charge can be framed or not. Now the issue is charge can be framed under, according to our stand, both UAPA as well as IPC provisions are applicable. According to them, till some time ago, it was only IPC which is applicable against them.
What,
Now that stand has been changed. Now they are arguing in favor of total discharge.
but
So
I want to clarify before learned senior counsel proceeds, Your Lordship. What I have said, Your Lordship, there may be case under section IPC sections. That's what I said.
yes,
Now it is up to this honorable court, Your Lordship, whether case is not there. But I say that at least section 15 will not come. That is what my case
Yes.
was, Your Lordship.
that's why my whole endeavor today from 10:30 onwards to impress upon this honorable court that section 16 read with section 15 is applicable. That was my whole endeavor. I have not dwelled the other aspect regarding the IPC provisions. So if I have to argue on those points, then Lordship, I'll have to take some more time. Now, whatever he has submitted, that we are totally relying upon the speech at page 274.
Yes.
So I would like to make my submission on this speech. If Lordship is pleased to come to the middle portion, I wanted on the right hand side, page 274, the speech of Okhil Gogoi in terms of the video number, serial number
275,
274.
274. Yes.
If Lordship is pleased to come to about 15 lines from top, I wanted to invite him. Have Lordship got it on the right hand side?
I wanted to invite him.
I wanted to invite him in Chabua. I wanted to invite Himanta Biswa Sharma once. Leave your jet category CISF person and come to Sabua to see the movement by wearing colored glass of BJP RSS, dreaming of what the seat of CM. What kind of speech you delivered? So he wanted a particular political personality to come without securities. What does it indicate? We have to read it between the lines. That come unarmed and will show you what is going to happen. So we have to look into the meaning here. If he wanted to show him the participation of people and how the movement was going on, he should be silent whether he comes with security or without security. But if a person comes without security, then what indication he has left here? That you come without security, then we'll show you, the people of Sabua will show you. This is provocation. That if you have the guts, come without security. Next page. Speech delivered by accused, translate so and so. Last 4 lines. I call everybody be unified. ASU, KMSS, AJYCP, all nationalist organizations of Assam, leftist organizations of Assam, and all political parties unified for the movement against CAB. Absolutely fine. Movement against CAB is fine. But whether that movement can be violent or non-violent, it is silent. Next line. And till CAB has not cancelled, we will not spare anybody. Is this not provocative? Till CAB is not cancelled or has not cancelled, we will spare nobody. So you come unarmed, don't cancel or don't repeal the CAB, and will spare nobody. So what is the meaning if you read both these statements conjointly? So he is not going, Okhil Gogoi is not going to spare any person, including Dr. Himanta Biswa Sharma, if he comes without security, until and unless he cancels or repeals the CAB. And if he has the guts, you come without security and will show you, will not spare you. So sparing is what here? That is not parliament. That the act can be repealed there. Any political person or any particular organization do not have to go to Sabua to repeal CAB. If you don't repeal CAB, then come and face the consequences. And this is what is the inner meaning and apparent meaning of this provocation. And next page, what the journalist produced the video, page 279. 3. In this clip, Okhil Gogoi A1 is welcoming the protesters. Fine, he can invite and welcome, give gamucha or whatever he wants, and saying that fire would be spread. Jui Jolise is not here. Fire will be spread. So what fire? Fire from his firearm. Other cases we are fighting, he was a part of Naxalite. All training programs, photographs we produced. There is another parallel case going on where charge has been framed under UAPA. He was receiving training and he was taking people from Assam to.
That is not part of the case, this
Arey,
case, Your Worship.
I was
have
not
objection
interfering.
to
I
that
was
one.
not interfering. I'm just giving the background of that person. So when he says fire will be spread, if that word is coming out from Samujjal Bhattacharya, ASU's leader, I would have accepted. Joya Afam, Jui Jolise. But when it comes out from a firebrand leader like Akhil Gogoi, his background we have to see. What is his background? These are all political things. That's why I'm saying. And these are all part of records. And before this court also, it is a part of record. The other case, which is a connected case. Those records are here only in the connecting case before the same division bench. So when this gentleman says fire will be sprayed, it is not a simple fire. And what is the consequence of that fire? Rail station was burned. The local MLA's house is burned. The circle office is burned. The UBI bank is burned. The Bengali locality is burned. This is not Jui Jolise. So it is fire of a different nature. So these three statements is sufficient enough to say that there was provocation, and that provocation ultimately culminated with this kind of damages, which amounts to terrorist act. Now coming to, my learned friend was referring to PW 30. To page 50. 3030. Yes. This is what my learned friend was.
Page 50, perhaps? Page
Yes, page 50, public prosecution witness.
3030, you said.
Page 50 of this paper book 1,
Period
volume 1.
30.
Page
Period
50, PW 30.
Yes.
This paragraph my learned friend was referring. I would like to place the whole.
Devorikhi.
Yes, Lordship. Devorikhi Chetia. So he belongs to one of the organizations, or he's a contractor. May I read paragraph? On being asked, I further state that unlike other organizations under the umbrella, our organization also took part in various protest programs in different places. But when the CAB was about to pass in Rajya Sabha, the movement became more intensified during the period of October 2019 till its end. Various organizations, including our organization under umbrella of Nagorikotto Hongshodhani Bidhayok Birodhi Moncho 2016, planning for various protest programs, including Rail Roko protest, march, meetings, etc. Accordingly, on 9/12/2019, people from local areas started gathering near Sabwa railway station and marketplace at around 5:40 to 6 p.m. Different leaders from various organizations like ATSA, AJYCP, DYFY, KMSS, etc. began to deliver their lectures regarding protest against CAB, where KMSS leader Akhil Gogoi and others also delivered aggressive and provocative speech. So others were giving and Akhil Gogoi was also giving. So that means it is not a case that Akhil Gogoi was not giving provocative statements. This was their reference now. So if XYZ was giving provocative and aggressive statements and also A1 is also giving, then we cannot ignore the provocative speeches of A1. Going further, in that program, larger number of people came out voluntarily in that meeting due to which road traffic was disrupted by I, along with other organizers, tried to clear the highway. The program of Rail Loco was there. So Akhil Gogoi was part of this whole program. One is that speech. He is a part of the meeting and he is a part of the Rail Loco. As per my knowledge, no permission from civil authority was taken to organize protest meetings, programs in Sabua on 9/12/2019. During that time, ADC Ranjit Kaur and others informed me about some protesters there were trying to create violence near the meeting place to disturb law and order situation at around 6:45 p.m. I heard one message that one CRPF vehicle was damaged by some protesters at about half kilometer from meeting place towards Panitola side. At that time, Tulumoni Dwara, SIOC Sabua station along with his staffs were near to me in his duty. As soon as he received the news, he along with staff went towards the PO where the CRPF vehicle was damaged. I, along with few of my companions, followed him. When I reached the place, I saw OC sir was attacked by protesters, causing serious injury on his face due to stone pelting. At that time, I saw Bhupen Gogoi, Bhaskarjit Phukon, Jagjit Guhai were along with other protesters near the damaged vehicle. And while I tried to remove one burning tire from the road, Swargaditya Phukon hit on tire with a sword, which he was carrying. Akhil Gogoi, Jagjit Phukon, Bhaskarjit Phukon, Bhupen were leading the mobs. What more is required, Lordship? Here? He was the leader. He was the pole bearer of the mob, along with others. May I read further? Further, I want to state that leaders from various organizations came to at that program separately, but I saw presence of Akhil Gogoi and other KMSS leaders from very beginning of the program. During that meeting period, I got information that some protesters were planning to set fire on the houses of Amravati colony, which is basically a Bengali-dominated area. I got alarmed and informed OC sir immediately to handle the situation. Accordingly, OC sir deployed police party. So there is categorical statement that Akhil Gogoi was present. He was leading the mob. He was giving fiery and provocative speech. Provocative speech also I am saying. These are the sentences he spoke. The video, these pen drives, Lordship, these are all in seal covers in the search sheet. We have flag mark. Lordship, may be pleased to look at. These are not opened also. So, from the statement which my learned friend relied, we are getting 3-4 very key points, key markers which triggered the violence. From this, we can very well adduce that Akhil Gogoi was present with the mob. That mob was involved in vehicle damages and other violent activities. He was giving speeches, and those speeches, the word he is aggressive and provocative speech. So he was giving aggressive and provocative speech. The sentence which the journalists produced before the authorities, before the IO, was the video where he said, spread the fire. If we connect all this sequence of events, it is more than sufficient to convince the learned trial court that this is a fit case for trial. Then another statement, Lordship, that was of PW 18, which my learned friend referred. I am just touching whichever my learned friend was referring. Statement of Biswajit Phukon at page 32. My name and address as stated above. I am a local correspondent of Proceedings Time during CAB, which has become CAA. I am in Sabua. On 9 December, Assam Band call was given by Krikhak Mukti Sangram Samiti and other organizations. On that day, evening time, there was huge gathering in Chabua town comprising of 6,000 crowd. Akhil Gogoi and some other companions arrived at the meeting venue at 6 p.m. The meeting was arranged near Sabua railway station. I was saying that it is near the station where the meeting had actually taken place. The meeting was arranged near Sabwa railway station. As soon as Akhil Gogoi arrived, he asked people to sit on the railway track to block the rails. Very categorical statement is there, Lordship.
This we have noted earlier.
Yes, Lordship. But this was, they are placing it again. So, to block the railway tracks, after some time, while the provocating lecture of chief guest Akhil Gogoi, there may be lot of other leaders. They are subordinates or leaders of lower ranks, but Akhil Gogoi was the highest ranked leader who was present. So he should take the responsibility also when he is leading a huge crowd and he is the main leader. His subordinates will also be responsible, but in a lower manner. Lecture of chief guest Akhil Gogoi was going on. People get more furious and started pelting stones on the security persons. So he was giving speech, and at the same time, simultaneously, the people were getting excited. What does it indicate? That there must be some incitement, some provocation, some encouragement, or some reasons to get the crowd triggered to indulge in illegal activities, violent activities. So these are categorical statements. How the trial judge could come over these statements? It has to be tested in the trial. He may be speaking 100% incorrect. It's a false statement. Let us assume. But to know that it is a false statement, it has to be tested. It cannot be a subjective opinion here. Or there should be a contra opinion somewhere else. But out of 42, more than 30, I am repeating again, are saying the same line of story. NIA is not that powerful organization to put words in every person's lips or mouth. That to a proceeding time journalist, a media person. So there must be some semblance of truth or genuineness or authenticity in this statement. But it has to be tested, Lordship. It is not that the prosecution will 100% believe, but whatever is stated under 164, 61, it has to be noted and it is produced before the court. He can become a hostile witness, but that hostility will come during the trial, not at the stage of framing of charge. And if any other leader is not put into the charge sheet or they are not accused, at that point of time, I think Article Section 319 was there. The trial judge at any point of time, Lordship was rightly saying that issue a notice and also consider him to be an accused person. Suppose there is leader of two other organizations who are not framed, who are not accused. They can always be called. Suppose Akhil Gogoi comes there, says that I was there, but along with me, SNS was also there. He was also making the same appeal. Then the court has every right to include that person also as one of the accused person. But that now will not give handle for the trial court to release this person or acquit him or discharge him. He cannot become scot-free. So another person can join the race, but another person's absence will not make him or get him the benefit of any positive order from the trial court. That means discharge. He cannot get discharge for that. If the prosecution has not included some of the other accused persons, the trial court can further direct that go for further investigation and complete your investigation. That power is also there under 173(8). That is why in most of the cases, additional charges are filed. ROC's case, Lordship is the classic example. The trial court directed for phrase and all were caught later on. The father, mother, and that person who was there involved. So this is a dynamic situation, not a static situation. So this charge sheet is one part. Tomorrow, few more accused person can also join them. If the court is convinced that some persons who are actually responsible for this they also have to be hauled up for these offenses. So may I continue? May I continue, Lordship?
Yes.
So chief case Akhil Gogoi was going on. People get more furious and started pelting stones upon the security person. Seeing hue and cry, I rushed towards the main road of NH 37 where the security persons were mainly present. On way, I saw OC of Chabua, Tulumoni Dwara sustained injury on his face and was bleeding. He told me that he was hit by pelting stones by the supporters of Akhil Gogoi. So Akhil Gogoi is the leader of a group of people. They were throwing stones. And that officer in charge, police officer, said that supporters of Akhil Gogoi hit me. I took the video footage of the injured OC as well as the meeting environment. Akhil's lecture was still going on. There was no peaceful environment, although the environment was already noisy. One bolero was also damaged there because of the instigational speech delivered by Akhil Gogoi. The bolero belongs to security personnel, probably of CRPF. So what more is required at this stage, Lordship? So my submission is that the speech, two forms of speech. One is that where he invited Dr. Himanta Biswa Sarma, come without security and face the music here. That is the inner meaning. He could have asked the chief minister to, at that point, I don't think he was the chief minister, whatever minister he was at that point of time, he was called. So come and see it. But why he has specifically mentioned, come without your security? Why? That which question has to be answered by Akhil Gogoi in the docs. He could have invited, very nice. He could have invited for a cup of tea, for a debate, for an argument, for participating in that movement also under him. All these things can be done.
For coming for a cup of tea, you don't need security. That is the meaning.
But
If
the
you
thing
come with
is that
security for a cup of tea, that will not look good.
now that is going on, Lordship. Now I am asking him for whom I am arguing today. So many chase friends, new friends, enemies. Now the problem with one of the party is that they have to remove all the posters because who was with them now is on the other side. So how they will keep all the posters and hoardings on a lighter vein, Lordship. So now he could have invited any person, any political functionary. But when he says, don't come with your security, remove your jet category securities, CRPF securities, then what is the indication? That shows that he has something else in his mind. It is not non-violence, it is violence. Because the security persons are kept to ensure security of that person from any physical harm. A person is not carrying a security with him just for the fun and sake of it. When there is a threat to his life, then only this jet category security, special CRPF security are provided. So when he says that come and without your security, then you will see what can happen to you. And when in the next speech he says, till the CAB and CAA, that particular legislation is repealed, we are not going to spare anybody. That sparing doesn't mean, what does it mean? And that sparing led to burning of the local MLA's house also.
Can we have a look at the charge sheet?
Yes, charge sheet. And I'll also take your lordship to the judgment also, to few lines. Charge. No, charge sheet.
Charge, at page 78. 78. 149 or 149.
66 to 92.
66 to 92, page number.
78 is the charge.
Lordship, yes.
Serial number 17.
Yes, Lordship.
Next. Yes.
Yes, charge is for prosecution under 120B, that criminal conspiracy, 143, 147, 148, 149, 326, that injury part, 307, attempt to murder, 333, 353, 427 of IPC, read with 16 of UAPA. So everything is covered here, Lordship. And we cannot, with the materials before this honorable court, I think in my humble submission and in my understanding, Lordship, section 16 is more aptly applicable. If the telephonic conversation, page 213, with his conversation with Kajol Gohain, it starts from 212, page 213. Being dormant, you have not done good. Okhil Gogoi said. The other said, I have not become dormant. Then next, no, this is not good. I have come to give some fire to make you warm. So these are metaphors. Of course, this can be a line of argument. But what does it say? What is dormant and what is active? A dormant is a volcano which is lying cool. It is not active, it is not in action. But once the fire comes out, it becomes very violent. So what does it indicate? That your becoming dormant or inactive is not good. I
would like to have these are transcripts made in.
Yes, the part is there.
translated. We want to have.
Yes, everything is there.
We want to hear the expressions used.
Lordship, the CDs and all.
It's in the audio also.
Yes. Everything is in the.
These are all transcription.
Yes, Lordship. These are transcripts. Very interesting, Lordship. If Lordship reads everything. Transcript. These were all examined in the yes, Lordship. We are leaving everything. In fact, we have submitted everything to the trial court, and Lordship was pleased to call it through the registry. It is already there.
It is already there.
LCR matan আছে in LCR টেবলেট থাকে তো
It is already there. No, Lordship, this is the from the court's record.
Court's
We have just
record.
marked it, Lordship. We have just marked it, Lordship.
we have marked it, we have flag marked. It is the pen drives are in seal cover. In that case, if Lordship wants to have a proper presentation, we can call the IO with all the equipment and also the PP from NIA. They can help assist Lordship whenever it is.
Pendrive we can have, but we like representation from either side.
Yes, our PP will be there, and the IO also, because he will know.
We can have it.
Because some hard disks are also there. Hard disks like ডাঙৰ ডাঙৰ কিছুমান লেপটপৰ পৰা খুলি আনিছে এইবিলাক চলাবলৈ ইও নোৱাৰিব আমি কি দায়িত্ব লব এইবিলাক
Okay, you can conclude. You have concluded almost.
No, if I have to argue on the IPC part, then I need 1 day's time, another date.
First, let us do one thing. We fix a date for an in-camera proceeding. Call the IO and whoever, your presence may not be required, but Mr. Bhattakur, somebody from your side,
Lots,
we just need your presence, we'll examine it.
lots.
And depending on the same, if we think that we need to hear Mr. Saikya on the IPC part, we'll have a date,
Lots.
okay?
And
Otherwise,
just one more thing.
Otherwise, we are all done, almost
Lots.
done.
My part is over. I will not submit anything more.
One of the judgment which my learned friends placed was that Samal's case, Union of India versus
Prafulla.
Yes,
Yes,
in paragraph 10,
yes.
subpara 4, that in exercising his jurisdiction under section 227 of the code, the judge, which under the present code is a senior and experienced court, cannot merely act as a post office or mouthpiece of the prosecution, but has to consider the broad probabilities of the case, the total effect of the evidence and the document produced before the court, any basic informatives appearing in the case, and so on. This, however, does not mean that the judge should make a roving inquiry into the pros and cons of the matter and weigh the evidences as if he was conducting a trial. So this is one part, and from the judgment, Lordship gives me only 2 minutes. I can the judgment part and the findings of the trial court. Page 135.
Just a minute,
Yes. Volume 1, page 135.
just a minute. Frame the charge for us to exercise the judicial but at the same time, loving and caring. No. 15 only for the purpose of taking with the prime facie as a case for materials, prime facie is used for a trial. And to that extent, it should be materials. Once of the view. Some of cases, suspicion and grave really good one into the special special power to dictate and to have a exception in cases with nothing to proceed. Because restore of judicial time for harassment to take place. Yes.
Page 135, paragraph 45. Analysis of materials and conclusions on the point of charge with regard to A1 Akhil Gogoi. Sri Akhil Gogoi. 45. Amongst witnesses examined by police during investigation, I find the protected witness A and witness 2, 3, 17, 18, and 30 are some of the eyewitnesses of the alleged incident. All these witnesses have stated that on 9/12/2019 in the evening, there was a large gathering at Sabua near Sabua railway station, which was also addressed by A1, and he gave provocative speeches there, and subsequently the crowd turned violent and started pelting stones, one of which hit the witnesses number 2, Sri Tulumoni Dwara, informant cum victim, grievously injuring his face. The nature of injuries sustained by the informant is clear from the medical evidence on record and the statement of witness number 19, C.R. Joshi, doctor. The witness have not stated that AY was directly incited the violence, but they had stated that he delivered provocative speech after the crowd turned violent. protected witness A also stated that the crowd turned violent. A1 did not denounce it or did anything to stop it. Witness number 2, informant cum victim, was also stated that when after sustaining injuries, he was being shifted away from the site. A1 was still addressing the gathering. In his statement, witness 18, Biswajit Phukon, a TV journalist, stated that after the vandalism, A1 and other remained at the site for an hour, and that this witness did not see A1 requesting the crowd not to vandalize. If we read this paragraph itself, there is sufficient materials to come to a conclusion that prima facie a case is there against A1. Prima facie. To counter these findings or factual situations, we have to examine all these witnesses, Lordship. He himself has 2, 3, 7, 18, 30. 5 witnesses he named along with witness A, protected witness. Plus witness number 18, Biswajit Phukon, the TV journalist, and the doctor. This overall materials which is placed before him and which he have accepted, the learned trial judge, is sufficient to make out a case of prima facie nature. Next paragraph. Witnesses like 5 and 8 have stated that crowd led by Okhilgo started pelting stones in the police party. But some of the other witnesses have stated that Okhilgo delivered an aggressive and provocative speech, and subsequently some members of the crowd started pelting stones in police party. Therefore, I find some differences in the nature of the incident narrated by these two sets of witnesses. Where is the conflict here? There is no conflict. One set says that while Okhil Gogoi was delivering the speech, people got excited and started pelting stones, injury, etc., and those vandalizing of the vehicles. Next says, 5 and 8 says, the crowd led by Okhilgo started pelting stones in the police party. So same line of events is going on. But some of the other witnesses have stated Okhilgo delivered an aggressive and provocative speech. So another sets of witnesses, Okhil Gogoi delivered aggressive and provocative speech. It is the sequence of the same line of action. It is not that Okhil Gogoi was singing bhajan there or doing some non-violent activities. No, same sequence is going on. And the learned trial judge cannot say some other sets of witnesses. He have to be very specific while analyzing also, at the preliminary stage also. It cannot be so mechanical, so casual. Witnesses like 5 and 8. Then what about the other witnesses out of 42? Have stated that crowd led by Okhilgo started pelting stones in the police party, but some of the other witnesses have stated that Okhilgo delivered an aggressive and provocative speech, and subsequently some other members of the crowd started pelting stones in the police party. Therefore, I find some differences in the nature of incident narrated by these two sets of witnesses.
Yes, what should we do? We have to rise. We have.
Then Lordship will kindly give, because this is a case of very serious nature of NIA. So I cannot leave any stone unturned to make my efforts to convince this honorable court.
No, definitely. Yes, but we don't want to prolong this.
Not a very long date, Lordship, because memories should be fresh for all the sides.
Next Monday, Tuesday. We can have it next Tuesday.
Yes, Lordship.
We'll finish it.
Lordship.
In fact, we have finished already.
Yes.
And you can touch on that part of it. And we can
IPC as well as this judgment also.
the judgment and
Where the learned trial judge when
okay. Just point out that
yes.
heard. Three, the secular senior counsel, assisted by Speaker K. Gogoi for the appellant. Also heard three as waterproof. learned counsel for the correspondence.
দিগদাৰ আছে নেকি কিবা? কাইলৈ ল'ব লাগিলে কৈ দে লাগে।
No substantial hearing has been done, the same has remained inconclusive.
Half an hour maximum.
The matter is inconclusive. Has remained inconclusive due to inconclusive. Again, for hearing on, we'll have it on Tuesday.
Lordship.
So this takes it.
24th.
On
4th.
24th. On that date, please have the IO also in the.
Lordship.
After completion of the hearing.
I think the main IO has retired or maybe he's
No,
going to
if
retire.
your colleague.
The other,
We just need to.
we'll call that IO. He's in Delhi. I think he's retiring on 31st.
Not required. We can just, we need somebody to operate the.
Yes, we'll call a very senior officers. All
Any
they will be
conversation?
yes.
Technical person is
And-
2 days.
Technical persons will.
Okay. After the hearing is over,
Lordship.
we will assemble in the
Lordship.
chambers in the presence of the learned counsel and we'll have a look at the speech and whatever. Okay.
Lordship.
Rest, a single bench matter, perhaps we'll have to give date. Motion, huh? Friday, More Friday.
তোমালোকৰ এইটোৰ লগতে আছে নে ক'ত আছে? তোমালোকৰ এপ্লিকেট কিবা আছে নে? ইয়াৰ লগতে এইটো বেলেগ লগতে তোমাকতো টাইম লাগিব। এইফালে কষ্ট কৰা তেতিয়া গম পাব।
Twins are all same, connected, I think.
Separate incident.
Separate
That is a Sanmari police station.
Your lordship may fix it, your after before.
Let that matter come on 24, then
We'll
Lordship.
finish this one and have matters. Single bench, court master will give date. If urgent, then tomorrow perhaps or day after tomorrow.